Page 1,
Page
item
1, 1 to 6.
कौन कौन सर?
Item 4.
हाँ, आपन ना सर?
Narayan Barik on behalf of Mr. Acharya.
आपन ना on behalf of Mr. Acharya केमते हो? अरे आपन ना on behalf?
Narayan Barik on behalf of
Narayan Barik on behalf of Ramdas Acharya for the petitioner. The matter was listed on 5-3-20 on 24-2-2026, 5-3-2026, 10-4-2026, and on each occasion it was adjourned by the learned counsel for the petitioner. Today also, the matter is mentioned being in the list seeking adjournment. To grant further opportunity to the petitioner, matter shall be listed in the week commencing 13-7-2026 for fresh admission. Yes.
Page 2, 8 to 13. Page 3,
Item
14 to
18.
19.
Item 18 million.
Yes.
After vacation.
Yes, 1 second. So, Samarendra Mahanti, item 18 लिखुଛନ୍ତି. The matter is filed without filing the certified copy of the judgment 1911-2024. এটা তো সার্টিফাইড কপি ডিসপেন্স করি হবে না?
সে আসো আফটার ভ্যাকেশন দিয়ে দিন।
আপনি ডিসমিস হয়ে যাও। এখন আপনার চয়েস না কোন? The matter was presented before this court. না মোড় আপনার আশ্চর্য হলে ମୁଁ କିଛି ଗୋଟେ ଅଲଗା କଥା କହିଲି କି? On presented before this court on दस एक 20-25 without enclosing a copy of the certified copy. The IA 6 of 2025 has been filed for dispense with certified copy. The prayer to dispense with filing of certified copy cannot be entertained. Since more than 1 year, 5 months, the petitioner has not bothered to file the certified copy, which is mandatory. The IA is dismissed. Yes. The petitioner, the matter being in the list is the matter being in the list is mentioned by the learned counsel for the petitioner. Seeking adjournment. Stop. After filing of the application, after 1 year and 5 months of filing 4 months of filing the application. Stop. Copy of this order shall be forwarded to the learned judge family court, Bhubaneswar, -2, to be kept in the records of judgment dated 19/11/24, passed in criminal proceeding number 283 of 2019. Yes, next. The matter shall be listed to grant further opportunity to the petitioner. The matter shall be listed in the week for fresh admission in the orders. The matter shall be listed for orders in the week commencing 20-7-2026. The certified copy of the order judgment shall be filed peremptorily by next week.
2 weeks after vacation.
After vacation ମୁଁ କେମିତି ଦେବି ଆଜ୍ଞା?
Within
ଆପଣ ଯୋଉ ପ୍ରେୟାରଟା କରୁଛନ୍ତି 16 ମାସ ପରେ ଆପଣ ମୁଁ ବୁଝିବା ଦରକାର ଯେ ମୋ ଅର୍ଡରର ଅର୍ଥ କଣ ହବ। ଆପଣ ଯଦି ଆଜି ଫାଇଲ କରିଥାନ୍ତେ କହିଲେ ମାଗିଲେ ଠିକ ଅଛି, ମୁଁ 16 ମାସ ପରେ ବି ପ୍ରେୟାର ଆଡଜର୍ନମେଣ୍ଟ ଦେବି। The matter shall be within 15 working days.
Oh, bless me.
Yes.
Pardon, Your Lordship, item 16. I have filed an IA for withdrawal, Your Lordship. During pendency of the writ application, already some.
16
Aye.
Mr. Ms. Kananbala Roy Chaudhary for the petitioner. Other side can't. I'm informed for
Contact details nahi.
for Vidya Ranjan Mehra regular counsel is it. The because state of key particular item 4
Item 16.
16.
permitted to be withdrawn.
Yes.
The order to pass out କରାଯିବ.
Obliged.
ठीक ଅଛି. Yes, next.
Lord, item 37.
नहीं
37.
20 ରୁ 24 25 ରୁ 27 20 ରୁ 27
Item 22.
24
22.
22
I seek adjournment after vacation, Your Lordship.
inform କରନ୍ତୁ.
I have taken consent from the opposite party counsel.
ଲାଷ୍ଟ ଅର୍ଡର କରିଥିଲା ଦେଖନ୍ତୁ. ଆପଣ ସାର୍ କୋଉଥିରେ appear କରୁଛନ୍ତି କାହା ସାଙ୍ଗରେ?
I am for the wife. Pooja Rasdev.
ହଁ ସାଙ୍ଗରେ ଆପଣ ୱାଇଫଙ୍କ ସାଙ୍ଗରେ କେମିତି appear କରିବେ? ଆପଣ ତ ଓକିଲ. ଆପଣ ସିନିୟରଙ୍କ ନାଁ ବି ଜାଣିନାହାନ୍ତି?
Devyata Mahapatra.
ଆପଣଙ୍କ ନାଁ କଣ?
Pratik Das.
ଆଉ ତ ପାୱାର ଅଛି.
Aye.
ଠିକ ଅଛି ସେଟା ପଢିଲା ବେଳେ ଦେଖାଯିବ ହେଲା କଲ୍ ହେଲା ବେଳେ ଦେଖାଯିବ ବର୍ତ୍ତମାନ ସମୟ let us not spend time on that କେବେଠୁ ଡେଟ୍ କରିଥାନ୍ତୁ ଫର ଅର୍ଡର୍ସ
ଓଡ଼ିଶା ଓଡ଼ିଶା
ସେ ମିଷ୍ଟର ପ୍ରତୀକ ଦାସ
Aye.
ଠିକ ଅଛି ସେକେଣ୍ଡ ମ୍ୟାଟରରେ ଆପଣ ହଉଛନ୍ତି ପିଟିସନର
22 of 25.
ଠିକ ଅଛି
Interim order to continue.
yes ଦେଖିବା କଣ ଏଣ୍ଟ୍ରି ମର୍ଡର କଣ ହେଇଛି ସେ ଆସନ୍ତୁ let us not second guess the entire proceedings ଠିକ ଅଛି
page 5 45 to 27
28 to 33 34 to 38 madam 37
Madam 30, my lord 37.
yes
I am for the opposite party, my lord, seeking adjournment next week.
ପିଟିସନର କୁ ଇନଫର୍ମ କରିବେ ନା
Okay.
ତା କରେକ୍ସନ କରିବାକୁ ପଡିବ ଟାଇପୋଗ୍ରାଫିକାଲ ଏରର ହେଇଯାଇଛି କେବେ ଡେଟ୍ କରୁଛନ୍ତି
And next,
ଓଡ଼ିଶା
yes
Number 38 and 39.
yes
Instead of matter, two matters are there.
you said that they are being listed
Korea Satra, so Sabuda Ekati has seen a sorry. And in the meantime, I have
if
instructed to
to
make.
deposit the amount of 50,000 at least
Yes, I have
to
told.
each of the
Yes,
each
to-
of the OP number 2
Pay the workmen them.
so Mr. in fact they are not coming
And I
because they think they have resolved to fate ଯେମିତିରେ ତ ମିଳିଲାନି କୋର୍ଟ କୁ ଯାଇକି ଆମ ଫେରେ ପଇସା ଖର୍ଚ୍ଚ କରିବୁ
But today.
did you mark yesterday he has not yet appeared on that ground it was urgent
Yes.
Mr.
but-
Lenka appeared for the state
But here today, my.
ସବୁଗୁଡାକ 27 କୁ ଯାଇଛି
Korea Satra, we commencing Korea Satra.
ତାହେଲେ ଲିଡ୍ କେସଟା କାଲି କେତେ ନମ୍ବର ଆଇଟମ ଥିଲା
That is in the mention in the number 8263 by 26.
But today list, somebody is appearing for the workmen. In two cases,
ତାଙ୍କୁ ଟିକେ ରିକ୍ୱେଷ୍ଟ କରନ୍ତୁ
again, so that.
8263 of
2026.
2026 এটা କାଲି ଥିଲା
No, এটা এই item 38 লেখা আছে সেখানে the lead case.
କୋଉଠି କହିଲେ ଆଚ୍ଛା ଆଚ୍ଛା adoption of counter in 8263
Yes,
8263 ଟା ଦେଖିଦେବେ କାଲି ଏଟା ଥିଲା
826 ରେ counter ଟା ପାଇ.
କାଲି ଆପଣ କାଲି କାଉଣ୍ଟର ପାଇଥିଲେ କପି କହୁଥିଲେ ନା Mr. Lenka is saying that this matter counter they are adopting so it was listed
Yes, yes, in all cases.
You know,
the list with हमको with commencing Odisha आते 2026. 38 लिखिए. Mr. Gain लेखा है for the P1, 1, 2, 3 was it? State party को लिखिए.
1, 2, 3. Should I pray for interim stay? Continuation of interim stay?
Let it continue because it is not, nothing is happening either way.
Sir,
Continue करे but there should be a purpose in continuing the litigation also. The matter being in the list is mentioned by the गोटे order कर देले तो सब गुड़ा
हाँ 38
common order
हाँ,
common order कर दियो. गोटे करते तो कौन अपन जो बहुत गुड़े टाइप करिया पड़ुची सेटा कमी जीव टिके गोटे कर सेटल कर दियो.
खाली read number उड़ा पड़ी.
नॉट सेटा पार्टी ना लिखे अपीयरेंस सब लिखा हो
आगे.
कॉन्स्टिट्यूशन ता गोटे है कि तळे ऑर्डर ता गोटे रहइबो. The matter is listed for admission, comma hearing. For admission dash hearing empty कर देवे. Is mentioned by the learned counsel for the petitioner. At the beginning of the day's proceeding, learned counsel refers to the earlier order dated for 25/3/2026. Stuff. He further submits that the connected lead petition WPC 8263 of 2026 was listed yesterday and has been posted to 27 to the week commencing 27/2026. Stop. The learned additional government advocate appearance लिखिएगा तो DN लेखा the learned additional government advocate तो लेखा हो चलती 1, 2, 3 4 none submits that the counter filed in the WPC 8263 of 2026 may be adopted in all the writ applications. Mr. Misra, I will pass that order adopting.
आगे.
Accordingly, it is directed that the counter filed in WPC 8263 of 2026 shall be adopted on behalf of the opposite parties 1, 2, and 3 in all the connected writ applications.
My learned friend has also
Extra
filed
copy दरकार.
memo file. कर
Yes,
दी.
we have also I did.
लिखिए जो submit लिखिए Mr. Lekha submits. What sentence आप open कर लो. हाँ. And the same way we are. हाँ. तापर link shot करंतु. The learned AGA submits that he has already filed memo
adopting.
Yes.
adopting the counter affidavit in all the writ applications.
Yes.
सबुथिरे गोटे मेमो फाइल करते हो कथा.
Samutra.
Copy of the तापर लिखले it is directed. आपनकर काउंटर गोटे देले हबो ना नै अधिका दरकार.
नहीं दरकार नहीं. गोटे.
Copy of the counter has been served on the learned counsel for the petitioner. Stuff. In some of the matters, the OP number 4 have not appeared. Stuff. Awaiting appearance of the OP number 4, the matter shall be listed along with WPC 8263 of 2026 in the week of, for admission in the week commencing 27/2026. Liberty to mention. ठीक है चेक कर देबे. काल किला कने चेक करके टाइप करी.
काली नहीं
काल
काली
केते थिला.
39
14/7/26
अच्छा ले स्टडी टा काट.
39 39 पड़ा
आपनकर मिस्टर मिश्र 8263 टा केबे को पोस्टिंग हेतिला.
आगुर
8263 आपण देखि देबे. डेट जेंती ठीक हो. नहले कोन हो ना सेटा गोटे अलगा डेट एटा गोटे अलगा डेट हिजो. आपण चेक करी कहिबे. ठीक हो. आपण कंप्यूटर जानि परिबे तो पोस्टिंग डेट टा.
सर
हां ठीक. से देखि कहि.
Thank you.
मोस्ट लाइकली 20 हेतिला. 39
same.
39 से.
39 सेम.
Right.
ताले 39 भी ऐड कर दियो. गोटे ऑर्डर करी की सबुतरे गोटे गोटे कॉपी रखि देबे. फोटो भी बोले से रखुचन रजिस्ट्री करछन. होचन. कहि देबे. यस.
item 1
Pardon to mention, item 26 to be taken
26.
up. Because he is suffering from cancer. 26.
26 Mr. Lenka is mentioning counsel not received. तो विषय कहा
Problem.
ठीक है just give him some because he may not be aware that the matter will be mentioned. The action to be ହେଲା kindly intimate Prabhu
Yes.
or prayers will do also.
I'll be into it. But the I will-
Prabhu listens to prayer, so let us keep praying. Yes, sir.
apex court order of play, differential of, for a directorial letter, they can. Item 1.
ସେ ଯୋଉଟା ଡିସ୍ପୋଜ ଅଫ ହେଇଗଲା ଯୋଉଟା ଆମେ ଅର୍ଡର କରିଥିଲୁ
Dispose
ବ୍ୟାଚ୍ ମ୍ୟାଟର କରିଥିଲୁ ସେଟା ଟିକେ ଡ୍ରାଫ୍ଟିଂ ରେ ସମୟ ଲାଗୁଛି ବିକଜ ଲିଟିଲ ଷ୍ଟାଫ୍ ଇଜ ଓଭରବର୍ଡେନ୍ ଦେ ଆର୍ ୱାର୍କିଂ ବଟ୍
ମାନେ ଇଏ କେସ୍ ଅଲଗା
ଦିଅନ୍ତୁ
ଡାଇରେକ୍ଟର ଲେଟର କରିଛନ୍ତି 5/5/26 ରେ କମ୍ପ୍ଲାଏ କରିବେ।
ନାଇଁ ନାଇଁ ଆପଣ କେସଟା ବୁଝିଛନ୍ତି
ଆଜ୍ଞା।
କନଫିଡେଣ୍ଟ ଫୋନ ବନେଇ ପଚାରିଛନ୍ତି ତ ଆପଣଙ୍କର ରିଟା ଆପଣଙ୍କର ଏସଏଲପି ଯାଇଥିଲା ନା ଯାଇନଥିଲା ଫାର୍ଷ୍ଟ କ୍ୱେଶ୍ଚନ
ଷ୍ଟେଟ ଅଫ ଫାଇଲ କରି ଆମେ
ଆପଣଙ୍କର କେସରେ ଏସଏଲପି ଷ୍ଟେଟ ଯାଇଥିଲା ଏସଏଲପି ନମ୍ବର କେତେ ତାପରେ ନେକ୍ସଟ କ୍ୱେଶ୍ଚନ
ମେନସନ ଅଛି
ଆଜ୍ଞା
98
ତାହେଲେ ଏଟା ରିଟ୍ ପିଟିସନ କେମିତି ଏଠି ରହିଲା ଯଦି ଷ୍ଟେଟ ଗଲେ ସେଦିନ ସାର୍ ପୁରୋହିତ ସାର୍ ବୁଝିପାରିଲେ କହିପାରିଲେନି ଲେଙ୍କା ଅଲସୋ ଇଜ ବ୍ୟାଫଲ୍ଡ ଯେ ଯଦି ରିଟ୍ଟା ଏଠି ପେଣ୍ଡିଂ ଅଛି ଆପଣ କହୁଛନ୍ତି ଯେ ଏସଏଲପି ରେ ଅର୍ଡର ହେଇଗଲା ବଟ୍ ହାଜ ଇଟ୍ ବିନ୍ ରିମାଣ୍ଡେଡ ହାଉ ଦ ରିଟ୍ ଇଜ ଲିଷ୍ଟେଡ ଆପଣ ଆଜି କହିଲେଣି ଯେ ସୁପ୍ରିମକୋର୍ଟ ଅର୍ଡର ପରେ ଡାଇରେକ୍ଟର କଲେ ମୁଁ ଡାଇରେକ୍ଟର ଅର୍ଡର କରିପାରିବେ ବଟ୍ ड्यूरिंग पेंडेंसी ऑफ द रिट पिटिशन ଆଉ ଯଦି ମୁଁ ଲେଖିବି ଯେ ଏସଏଲପି ଅର୍ଡର ପରେ ଡାଇରେକ୍ଟର ଅର୍ଡର କଲେ କେସରେ କେମିତି ସେଟା ହାଉ ଡଜ ଇଟ୍ ବିକମ୍ସ ଇନକଂଗ୍ରୁଅସ୍ I am taking up WPC 1490T of 2013 that is still pending ଆପଣ ଅର୍ଡର ଶିଟ୍ ବି ଦେଖି ପାରିବେ ଏଠି ଅଛି ଦେଖନ୍ତୁ
ପେଣ୍ଡିଂ
ମିଷ୍ଟର ଶେଖର
second item.
ଆପଣ ସେକେଣ୍ଡ ଆଇଟମ ଖୋଲୁ ନା
Similar, 1 and 2 and similar.
ୱାନ୍ ଟା ଟିକେ ଦେଖନ୍ତୁ
It is pending election.
ଆପଣଙ୍କର so Mr. you are clear that it has not been disposed of and not challenged by state yes Mr. Shakti Sekhar
My lord,
you are clear that this is pending before High Court
it is pending.
pending so that is, I think that is the correct position
Right.
but ଆପଣ ସେଟା ଏତେ ଇନସିଷ୍ଟ କଲେ ଯେ ସେଟା ଏସଏଲପି ଅର୍ଡର ହେଇଛି so ବହୁତ ଖୋଜା ଲୋଡା କରିକି ସେ ମିଳିଲାନି ଆମେ ଫାଉଣ୍ଡ ସମ୍ ଅର୍ଡର ଅଫ ଜଷ୍ଟିସ ପ୍ରସାଦ
But certainly the matter was carried to the Honorable Appellate.
so yes connected matter was carried
My lord. And a civil appeal was also preferred in my.
ଏଟା ଟିକେ ମେମୋରେ ଆପଣ ଗୋଟେ ଏଟା ପାସ୍ ଓଭର କରିଦବା ଆପଣଙ୍କର ଏଇଟା ଡାଇରେକ୍ଟ ଚିଠି ଲେଖିଲେନି
More kishi lekhi nanti.
ଲେଟ୍ ଇଟ୍ ବି ଡିସ୍ପୋଜ୍ଡ ଅଫ
My lord.
ସେଇ ସିମିଲାର ଆପଣଙ୍କର ଜଜମେଣ୍ଟଟା ମିଳିବ ଏଇଟାକୁ ଗୋଟେ ଜେରକ୍ସ କରିକି ଦିଟା କରିବେ ଆପଣ ସାର୍ ଗୋଟେ ମେମୋ ଲେଖିବାକୁ ଦିଅନ୍ତୁ ପାସ୍ ଓଭର you will look at that judgment which has already been disposed
My lord, I will verify that.
so just wait
My lord, as lordship.
ଏଇଟା ଯୋଉ
Civil appeal action.
ତିନିଟା ମ୍ୟାଟର ଥିଲା ସୁପ୍ରିମକୋର୍ଟର ଅର୍ଡର ଅନୁସାରେ ହେଇଛି କରିଥିଲେ ଗୋଟେ କପି ବାହାର କରି ମିଷ୍ଟର ଶିଶିର କୁମାର ପୁରୋହିତ ମିଷ୍ଟର ଡିଏନ୍ ଲେଙ୍କା ପାସ୍ ଓଭର
My lord.
ଆଇଟମ 3 ତ ଆପଣ କରିକି ଦେବେ ଆପଣ କରିଦେବେ ଗୋଟେ କପି ସର୍ଭ କରିବେ ଲେଙ୍କା ସାର୍ଙ୍କୁ ଗୋଟେ ଏଠି ଫାଇଲ କରିବେ ଆପଣଙ୍କୁ ବି ଅର୍ଡର କରିଦେବା ସାଙ୍ଗରେ Did you talk to your client, Mr. Lekar? Any contact?
I was told that yesterday an application sent after disposal of the civil appeal, wherein 3 months was granted to the director to take a decision. A further application was filed in that disposed of civil appeal to further grant some extension.
Correct.
So another 1 month time has
Mr.
been
Lekar
granted.
was saying that the 3 months period is over because Mr. Purohit insisted that it is by the Supreme Court order.
And
They
yesterday,
have granted further time in light of the Supreme Court order.
my lord. And
So
yes,
I'll show you that.
My lord.
Already Mr. Purohit has argued it.
My lord.
I'll show just.
And yesterday I was told that a further extension has been granted by the Honorable Apex for further 1 month time has been granted.
In any event,
That is
Mr.
the
Sekar,
point. My lord.
I cannot say that since Supreme Court has granted 3 months in the SLP, here also I'll grant.
Can be disposed of in terms
So
of the.
because January ରୁ 3 ମାସ ତ ସରିଲାଣି.
My lord.
January ନା February କେବେ?
That's
29
April.
ଠିକ ଅଛି 29 so 29 2 3 4 29 4 ରେ
29
ସରିଗଲା.
4 ରେ ସରିଗଲା.
That was yes let us see Mr. Tripathi
My lord.
pass over ଆପଣ ଟିକେ ଅପେକ୍ଷା କରନ୍ତୁ.
ଏସଏଲପି ନମ୍ବର ବି ଏଥିରେ ପଡିଛି ସେ
ଟିକେ ପଢୁନାହାନ୍ତି ଆପଣ କଣ ଭାବୁଛନ୍ତି ମୁଁ ପଢିନି ବୋଲି ଆପଣ ତ ଲେଟରଟା ପଢିଲେନି ଆପଣଙ୍କ ମ୍ୟାଟର ଯୋଉଟା କହୁଛନ୍ତି ଏଇଟା ଗୋଟେ ଇମ୍ପ୍ରୋବାବଲ ଜିନିଷ ଯେ ଏଠୁ ହାଇକୋର୍ଟରେ 13 ମସିହା ରିଟ୍ ପେଣ୍ଡିଂ ଅଛି ସୁପ୍ରିମକୋର୍ଟ ଏସଏଲପି ଡିସ୍ପୋଜ ଅଫ୍ ହେଇଗଲା who will file SLP why they will file SLP ଆପଣ ସେଟା ତ କହୁଛନ୍ତି ଷ୍ଟେଟ ତ କହୁଛନ୍ତି ଆଜ୍ଞା ଆମେ ଯଦି ଫାଇଲ କଲୁ ଏଠି ପେଣ୍ଡିଂ କେମିତି ହେଲା କନେକ୍ଟେଡ ମ୍ୟାଟର ସାର୍ ଯୋଉ ଧରନ୍ତୁ 8-10ଟା 50ଟା କି 100ଟା ମ୍ୟାଟର 63ଟା ମ୍ୟାଟର ବୋଧେ ଆଇ ହାଭ୍ କାଉଣ୍ଟେଡ ଇଟ୍ ଅଲସୋ ହାଭ୍ ରିଫ୍ଲେକ୍ଟେଡ 63ଟା ମ୍ୟାଟରରେ ଏସଏଲପି ଫାଇଲ ହେଲା ଯୋଉଟାକୁ ହାଇକୋର୍ଟ ଅର୍ଡର କରିଥିଲେ and few of them are by the Honorable Justice Sujit Nar SN Prasad relying on Mamata Mohanty. At least we have done our homework when we were discussing. So he has said that it shall be considered in terms of Mamata Mohanty. ଆପଣ earlier order ଟା enclose କରିଛନ୍ତି କି Shekhar?
My lord,
Have you enclosed the earlier order?
earlier order passed in,
Connected matter रे Justice Prasad का order.
no, my lord, that is not.
That is the problem. ଆପଣ ଯଦି earlier order ଟା ଦେଖି ଦେଇଥାନ୍ତେ ସେଇଠୁ ସେ SLP reference ଟା ମିଳିଥାନ୍ତା. Because SLP does not show any writ petition. So we cannot know.
state instruction ଦେଇଦେନ
State କେମିତି ଆଜ୍ଞା ଆଣିବେ?
That writ
ଜବରଦସ୍ତି
petition
କେମିତି
have
ସେ ତ ଫାଇଲ କରିନାହାନ୍ତି. So how can I say that you find out whether SLP is filed by you or not when I am myself handling the writ petition.
ଆମର SLP number
I was
ହଉଛି
going through the
9866 of 2024
Arising out of sir. Muted ହେଇଗଲେ arising out of
arising out of
Your Worship, that is WPC 24167 of 2012.
24167 24168 returns.
My lord.
You are Mr. Das,
Honda
Mr. Ponda. For power नहीं
ନା 913 number power
Mr. सीधा आसो करियो सीधा एक आसो. Yes, Mr. Tripathi. ଆପଣ କରିଥିଲେ ହଁ ଟିକେ ଦେଇକି ଆଗ ହଁ ଆପଣ ଆଗ କହିଥାନ୍ତେ ନା ମୁଁ ବୁଝିବାକୁ ପଠେଇବି କୋଟେ ନିଏ
my lord
ସେ ପଣ୍ଡା ଆରେ ଆପଣ ମେମୋ ଦେବେନି ଆପଣ ପାଇଁ ଜେରକ୍ସ ଆପଣ ପଳେଇଲେ ଗୋଟେ କପି give to the landed AG ଗୋଟେ ତାକୁ ଦିଅନ୍ତୁ ଆଉ ଗୋଟେ ମେମୋ ସେମିତି ଏଠି ରଖୁଛି. Yes, Mr. Tripathi.
My lord, but the petitioner challenged the maintenance, my lord. My lord, petitioner was earning per month, my lord, only 3,380
Fair
rupees
enough.
pension, my lord.
Suppose he is
My
earning
lord, actually,
he is earning zero.
my lord, actually,
ସେ କୋଉ ପେନସନ ପାଉଛନ୍ତି ଏଟା
my lord,
3000 ପେନସନ
ସେ ଯୋଉ
କଣ ଥିଲେ ସେ
ଫରେଷ୍ଟ ଡିପାର୍ଟମେଣ୍ଟରେ ଥିଲେ ସୁପରଭାଇଜର
ତ ତାଙ୍କର ଲାଷ୍ଟ ପେ ରନ୍ LPC
ମୁଁ ଜାଣିନି ମ୍ୟାଡମ
ଏଟା ଜାଣିବେ ନା ଆଉ sir you are sir
actually what happened
Mr. Tripathi your first job is that
Madam.
whatever the client comes to you and speaks to you
Madam.
you must apply your logic legal knowledge. Suppose he comes that my pension is say 50,000 or 50 lakhs. So you should ask him that
what happened, my lord, actually what happened, my lord?
नहीं ଆପଣ first of all ପଢିଛନ୍ତି କି
My lord,
pleadings ଦେଖିଛନ୍ତି
ଆଜ୍ଞା ସେ ତା ସ୍ତ୍ରୀ ହିଁ ନୁହେଁ
ସେଇଟା ନା 125 ରେ ନାହିଁ ସ୍ତ୍ରୀ ହିଁ ନୁହେଁ ଏଟା ଅଛି ସେଥିରେ
my lord ସିଏ
ଆପଣ ଯୋଉଟା କହୁନାହାନ୍ତି କି
my lord ସେ ଗୋଟେ ଆଧାର କାର୍ଡ
ଆପଣ ଏଟା ପଢିକି କହୁଛନ୍ତି ନା ନାଇଁ ଭାବୁଛନ୍ତି
my lord ପଢିକି କହୁଛି my lord ଆଧାର କାର୍ଡ
କୋଉ ପ୍ରୋଭିଜନ ରେ
my lord ଆଧାର କାର୍ଡ ଟା
ଆରେ ତ୍ରିପାଠୀ ପଢୁଛନ୍ତି କୋଉ ପ୍ରୋଭିଜନ ଅଛି ଯେ ସ୍ତ୍ରୀ ହବା ଦରକାର 125 ରେ ମେଣ୍ଟେନାନ୍ସ ପାଇବା ପାଇଁ
ୱାଇଫ
କଣ ବର୍ତ୍ତମାନ ମ୍ୟୁଟେଡ ହେଇଗଲେ
ୱାଇଫ ତ ହେଲେ ହିଁ ମେଣ୍ଟେନାନ୍ସ
ମାଇ ଲର୍ଡ ୱାଇଫ କଣ
my lord ୱାଇଫ ହେଲେ ହିଁ
ପଢନ୍ତୁ ଟିକେ ଆଜ୍ଞା
my lord
ଏଇ ଯୋଉ କଥାଟା ଆପଣ କିଏ କହିଲା who told you that ସ୍ତ୍ରୀ ହବା ଦରକାର କଣ ଆପଣ ମତ ନେଲେ ମୁଁ ଆପଣଙ୍କୁ ନେଲି ଆପଣଙ୍କୁ ପାସ୍ ଓଭର କରିବାକୁ ପଡିବ ବର୍ତ୍ତମାନ ସବୁ ପାସ୍ ଓଭର ଚାଲିଲା
after vacation
ଆଫ୍ଟର ଭ୍ୟାକେସନ ନୁହଁ ଏ ଆଡଜର୍ନମେଣ୍ଟ ମତେ ମୋର ସମୟ ମୋର ବାଇ ଟାଇମ ଇଜ ଭ୍ୟାଲୁଏବଲ ଆପଣଙ୍କ ମ୍ୟାଟର ଲିଷ୍ଟ ହେଲା କେତେ ମ୍ୟାଟର ଲିଷ୍ଟରୁ କଟିଲା ଆପଣଙ୍କର ମେଣ୍ଟେନାନ୍ସ ଗୁଡାକ ମାନେ ଇଣ୍ଟରିମ୍ ମ୍ୟାଟର ବୋଲି ଆଗ ଲିଷ୍ଟ ହବ ଅନ୍ୟ ମ୍ୟାଟର ହିୟରିଂ ହେଇପାରୁନି ଲାଭ କଣ ହେଲା
after vacation ଆସୁନ
ନାଇଁ ନାଇଁ ଆପଣଙ୍କ ଆଫ୍ଟର ଭ୍ୟାକେସନ କଣ ହେଲା କହିଲେ ଆଇ ୱିଲ୍ ବି ଲିଭିଂ ୟୁ in a situation where your thought process is completely bereft of law in darkness. Adjournment to मिलिबो but problem नहीं, but at least this submission will never make when you are being watched.
Mile.
You are being watched in YouTube.
Mile.
Your से ओडिया जे बुझते से तो बुझी परिबे स्त्री नुहो बोली
Mile.
125 रे स्त्रीटा इंग्रेडिएंट बोले आपण भाबी देइछंती कि आपण ये कहिसंती आउ कोन ग्राउंड नहीं स्त्री नुहो आउ कोन
My lord,
आपण तो देखि नांती मते लागुची आपण रिटन स्टेटमेंट देखि नांती जेतेबेले आपणकर आसिले महकिल आसिले आपण कथा सब कहिले आपण कहबे आज्ञा देखांतु आपण अर्जीटा जोटा देइथिले जवाबटा देखांतु
my lord.
से नले आपण अंडर एस्टिमेट करिवे तांको भितरे से भाबे वकील मु कहली से करि पारलेनी सैंतीस 38 अड़तालीस पढ़ो सर को दियो एटा 30 सेकंड को दियो सेटा आपण मिस्टर लेखा को भी देखे देबे आपण से ऑर्डर हेजो
Mile.
तम पाखरे बस को देखे दे अरे आपण म्यूटेड पढ़ले कि घरे निर पठन करिवे कोर्ट रे पढ़ले सो दैट मु बुझी परिबे आपण को पढुछंती 37 पढो
37 mile.
37 38 39 टी क्विकली पढो
Well, this court held that the object of the maintenance of the proceeding is not punish the proceeding is past, neglected, but prevent the vagrancy and destitution of deserted wife by providing her food, clothing, and shelter by the speedy remedy. Section 125 CRPC is measure of social justice, excessively escape protect women and children and fall within the constitutional sweep article 15 plus 3 reinforced of the article 39 of the constitution.
15 3 और 39 देखछो दी सर एनीवे ठीक है तापरटा पढो सर
Proceedings under section 125 CRPC is a summary.
स्लोली पढिबे
Proceedings under section 125 CRPC are summary in nature in the Bhuvan Mohan Singh versus Meena. This court held that the section 125 CRPC constitute the
आपण कोन चश्मा यूज करनो एपन लागिनी आपनकर
देखंदे डरी जाउ
खराब होबो सर
चश्मा लगेले सब लगे पड़िबो
सर दिस इज वेरी रॉन्ग कांसेप्ट सर वेरी रॉन्ग कांसेप्ट आपण जदी चश्माटा लगेबेनी आपण आखिटा निश्चित भाव इंपैक्टेड हे जिवो
थरे लगेले सब लगे
अरे थरे लगेले सब लगे नो यू शुड नॉट स्ट्रेन योर आईज आपनकर आखिर गोटे प्रिंसिपल होची ऑडियोटा बंद कर
support to the wife and minor children. The husband was and minor children. The husband was required to earn money even by physical labor if he is able to bloodily and would not avoid the obligation expect on any legal permissible ground to maintain in the status. The issue whether the presumption of the marriage arising when the parties are in a live-in relationship for a long period of time.
तो एई जिंसटा आपण त कहिथार शुड हैव बेस्ड योर स्टैट्यूट
मतलब से लिव-इन ने भी नहीं
उडन तो आपनकर प्रॉब्लम हला जे यू बाट मने रॉन्ग ट्री 125 फाइन हला आपण चली गले वेदर सी इज योर वाइफ और नॉट एनी काइंड ऑफ रिलेशनशिप
मतलब
तो सेटा दियो
मतलब से लिव-इन ने भी नहीं
व्हाटएवर कोन का कोन कहबी आपण छाडंतु आई विल शो यू अ जजमेंट ऑफ सुप्रीम कोर्ट
मतलब
of this bench has been confirmed by the order has been confirmed the same plea
मतलब ताकर आउ जने हस्बैंड अछंती ये आसी कि माने
आज्ञा ताको हस्बैंड को आनी थांते ଆପଣ ଯେତେବେଳେ difficulty ଯେତେବେଳେ ଆପଣ ଯେତେବେଳେ ସେ ଯେତେବେଳେ claim କଲେ,
My lord.
what is that name of that suit? ସବୁ ଜିନିଷ କଣ access କଲେ ହବ ଆପଣ? ଆପଣ ତ it was held that where a man and a woman have cohabited for a long period of time in the absence of legal necessities of a valid marriage, such a woman would be entitled to maintenance. A man should not be allowed to benefit from legal loopholes by enjoying the advantages of a de facto marriage without undertaking the duties and obligation of such marriage. So this is the view. It has been now confirmed by Rajneesh versus Neha. It has been circulated throughout country.
Well,
You
what
must understand. So you should
But
not have taken their plea.
କିଛି connection ତାଙ୍କ ସାଙ୍ଗେ ତାଙ୍କର ନାହିଁ. So after
ପ୍ଲେଣ୍ଟ ଦିଅନ୍ତୁ ଦେଖାନ୍ତୁ ଆପଣ ପ୍ଲେଣ୍ଟ ହିଁ ନାହିଁ
after 35 years
ପ୍ଲେଣ୍ଟ ନାହିଁ ଆପଣ 35 ଆପଣ ପ୍ଲେଣ୍ଟଟା ତ ଦେଖିବେ ସେଠୁ ଆରମ୍ଭରୁ କହିଲେ ପ୍ଲେଣ୍ଟ ପଢୁଛନ୍ତି ଦେଖାନ୍ତୁ
melody in ground stream ଲେଖିଛି after 35 years back which has been disputed by the present petitioner and
ପାରା 2 ପଢିଲେ ପାରା 2 ପଢିନାହାନ୍ତି ପାରା 2 the judgment. The hard on counsel for the petitioner Bhamakesh Tripathi. For the petitioner, you take your seat. I'll dictate the order. Bhamakesh Tripathi for the petitioner, opposite party blank. The petitioner before this court is the husband in the marriage. He has challenged. The petitioner before this court challenges the judgment dated 3/12/2024 passed by the learned judge family court both in criminal proceeding number 23 of 2023. The opposite party herein, who was the petitioner before the learned judge family court, filed the said proceeding, said petition under section 125 CRPC, seeking maintenance at the rate of rupees 7,000. It has been stated by in the application, noted by the learned judge family court that the marriage between the opposite party and the petitioner herein was solemnized 35 years back. From the wedlock, 2 children, 1 son and 1 daughter were born. Then the present petitioner was working as supervisor in the office of the divisional manager, Orissa Forest Development Corporation, both. It is further stated that the petitioner had accepted one lady of village Bakipada under both police station as his second wife about 30 years back. Thereafter, he started neglecting his wife and children. The pension amount received by the petitioner is stated in the application to be 25,000. The present petitioner appeared and filed his written statement denying the marriage with the opposite party. He denied having blessed with 2 children and stated that he married one Kuni Sahoo, another lady on 10/7/1986. And after retirement, he is receiving rupees 3,380. The learned court has examined. Learned court. No, the before the learned court, the opposite party wife examined herself as PW1 and another independent witness as PW2. The opposite party examined himself as OPW1. The petitioner relied on documents marked as exhibits 1 to 1, TO 2, 3. OP relied on documents marked as exhibit A to H. Stuff. The opposite party proved her case as stated in the pleadings. He withstood cross-examination. The PW2 also stated in his evidence, which remained unchallenged, that the petitioner wife and the opposite party husband were married. They live as husband and wife, and they have 2 children. The documents exhibited by the petitioner are public documents. That is a green card issued by the Chief District Medical Officer, Kandhamad. Exhibit 3, which shows the petitioner as husband of the opposite party and mentions the name of the 2 children. Similarly, Exhibit 2 also showed that petitioner to be wife of the opposite party, petitioner to be the husband of the opposite party. The bank passbook also disclosed. The petitioner to be husband of the opposite party. Regarding the exhibits 1, 2, and 3, adduced by the marked by the opposite party. Cross-examination was not done. Therefore, they have remained. Therefore, they remain unchallenged. Somehow, the present petitioner tried to prove his marriage to another lady by producing the card, invitation card. Marriage invitation card with the other lady. The petition was favored. However, granting monthly maintenance at the rate of 5,000. From the date of filing of application, dated 27/7/2023. ଆପଣ डिपोजिट करिवे एरियर टा पूराटा
installment
इन्स्टॉलमेंट हेई परियोनी
पैसा नाही ता
मु गुड पैसा आनी आई हैव टू ऑनर आपण ऑनर करि न परंती आई कैन नॉट जस्ट थ्रो अवे द डिक्री झरका खोली बाहर पकई देबी बिकॉज़ मो हाई कोर्ट सो लोअर कोर्ट डिक्री आई हैव टू थ्रो इट एंड दैट टू ऑफ ए डिस्ट्रिक्ट कोर्ट
मतलब installment
से प्लीटा कोर्ट नेथिले पैसा नै बोली इंस्टॉलमेंट प्ली कोर्ट नेथिले Sir, you have to tell this thing to your, that is how you will be respected as his legal, otherwise it leads to nowhere. On being asked, the Lorded Counsel for the petitioner submits upon instruction that the petitioner remains in default of the amount directed to be paid of TC. The total amount due since 27/7/2023 comes to 2,25,000. Para. Challenging the judgment passed by the lauded family court is submitted by the lauded counsel for the petitioner that the opposite party is not his wife. Whether such a plea can be countenanced in an application seeking maintenance under section 125 of CRPC has been dealt with by the Honorable Apex Court at length in Rajnesh versus Neha petition paper, paragraph 37, 38, 39, 40. As has been further directed by the Honorable Apex Court, the amount due the monthly maintenance granted is akin to a money decree. In order to sustain the challenge before this court, the learned counsel for the petitioner was asked whether he will secure the amount by depositing before the learned family court. He submits that the petitioner cannot pay. Para. The petitioner shall file affidavit indicating his last paid run, the total retirement benefits received, the details of his employer by the next date, as adjournment is sought for on behalf of the learned counsel for the petitioner. The matter shall be listed for fresh admission in the week commencing 13/7/2024. Same order.
Same order.
Obliged.
Yes.
Mr. Ponda पळेले ते कोण पास ओवर कले पळेले সেটা কল করিবে যে কোন পড়েলে নি কোন সেই অর্ডারটা আইটেম 2 আইটেম 1 রে भी আইটেম 1 রে से মেমোটা আপন মেমোটা দেখিলে কি কোন মেমো ଦେଇଛନ୍ତି
मैं खाली ऑर्डरটা देता मेमो କିଛି देता
आइटम 1 টা লিখন্তু মিস্টার Suanshu Ponda on behalf of Sisir Kumar Purohit for the petitioner. Mr. D.N. Lekha, IGA for the opposite party. The matter was presented before this court on 3/7/2018. And is kept pending since then. During pendency of the writ application, similar matters were disposed of. The state disposed of by coordinate bench. The state has gone to the state preferred SLP against the state order of the coordinate bench, which has resulted in disposal of the SLP. Hongo se jo order copy ta
এটা
এইটা जो এটি আপনারা কোড করে নেন এই নি কিন্তু এইগুলো এটা পুরোটা লিখে দেব resulted in SLP number a civil appeal number 9828 of 2024 and 64 connected civil appeals. Stop. The matter has been listed. এটা তারপরে para 2 repeat করে দেন para 2 3 সমান আছে 2 3 এটা আপনি আইটেম 1 করছেন item 2 টারে କହିବେ ଆପଣ ହେଲା ତାପରେ ଲେଖନ୍ତୁ the learned counsel Mr. Panda files memo of date enclosing copy of the office order issued by the government of Odisha Department of Higher Education by Director Higher Education dated 5/5/2026 office letter कर दियो तू address to principal Ancholiko Kisan College से पार्टी अछंती इतरे पार्टी ना where এইটা কোন তো তোমার বই where it seems the petitioner had worked as lecturer in English, though in the writ application he has stated to be working in 2013 as lecturer in English in Burla NSC College, Burla, district Sambalpur. Stop. Copy of the memo along with enclosed office letter is served on the learned AGA. The memo and the enclosure is also taken on record. Scan copy be updated. Stop. A perusal of the letter indicates that after disposal of the civil appeal number 9866 of 2024, State of Odisha versus Santosh Kumar Bhoi, by order of the Honorable Apex Court dated 29/2026, the state authorities have acted in the same. It is also informed by the learned counsel for the petitioner that the time period for consideration as directed by the Honorable Apex Court has been extended by 1 month further. Stop. In view of the above developments, the writ application is disposed of. The order passed by the Honorable Supreme Court disposed of पूर्व आपण एटा करि परिबे para 5 6 6 5 6 8 8 9 10 11 এটা আইটেম 1 রে গলা 2 রে লিখিবে যেহেতু তাଙ୍କ ପାଖରେ ନାହିଁ 2 ଟା আইডেন্টিক্যাল অর্ডর মিস্টার Shakti Shekhar on behalf of SD Rautray. SD Rautray for the petitioner, Mr. DN Lenka.
Let me indicate S Chennai, Lordship.
S Chennai.
It's D Rautray.
Acha, sorry. She is D Rautray. So Shakti Shekhar on behalf of S Jenaf. So DN Lenka IGA for P1 and 2. এটা এই অর্ডারটা করতে এটা আইটেম মানে both are disposed of.
Yes.
1230 ocean record. Item 7. Call করুন.
Item 7.
Yes.
Your lordship directed to ensure the presence of the
Yes.
branch manager, my lord.
Yes.
I was informed by this IIC Carbon
Yes.
that the manager investigating litigation will be appearing in court today, my lord. And he is present, my lord. Here is the
Today is April.
Yes.
Today I am filing the affidavit.
Yes. Mr. Sheikh Ruplal.
Yes, ma'am.
You are SK or Sheikh? Mr. Sheikh Ruplal.
Short রে সেটা এসকে রে সার্টিফিকেট বলছি সিটিসেন
No, I understand. But whether it is S.K or Sheikh.
এসকে ডট
Mr. Sheikh Ruplal for the petitioner. Yes. It is submitted by the learned counsel, Mr. The state with the party now.
না স্যার এটা
it is not a party.
It is okay.
Directed
Yes, ma'am.
ensure
The matter is taken up having being marked at 12:30 p.m. today. It is submitted by Mr. Sheikh Ruplal, Learned Counsel for the petitioner that he is filing affidavit on behalf of the petitioner as directed by order dated 8/5/2026. Stop. The affidavit is filed in court. Shall be taken. Affidavit is no. The affidavit filed in court shall be taken on record. Copy of the affidavit. Copy of the affidavit be served on the Learned Additional Standing Counsel. Stop. The Learned Additional Standing Counsel provides the instruction as directed by order dated 13/5/2026. Upon instruction, Mr. Mahanti.
No, yeah.
Copy achi.
Yes, sir.
The Learned Additional Standing Counsel, Mr. Prem Kumar Mahanti, furnishes the communication received by the Inspector in Charge, Hon'Ble Nagar Police Station, Bhubaneswar, from an officer of SBI General Insurance Company Limited. The signature being short signature, though not legible, which indicates the following. The said copy of the letter produced by the Learned AC shall be taken on record. Will be kept on record, scanned copy be updated. Who is present, Mr. Rupla?
Legal manager.
What's his name, sir?
Sunil
The Learned Counsel, Mr. Ruplal, submits that so and so, takoro na address or designation, so and so is present as directed by the Learned, by the order dated 8/5/2026.
Your lordship, that person, he has already shown the affidavit. Today affidavit.
No, whoever is present, say
nije affidavit ଦେଇଛନ୍ତି sir.
You sir present ଅଛନ୍ତି, see affidavit
ଆଜ୍ଞା sir.
Yes.
Yes ma'am.
It is submitted that Sri Godnaik has also sworn the affidavit as directed by order dated 8/5/2026. The affidavit discloses the following. In the affidavit, the following statement has been made. Para 1 and 2. Para 1, 2 and 3. Para. In view of the in view of the categorical statement made in the affidavit that the petitioner, the company, the petitioner company have not agreed for award amount before the permanent Lok Adalat Khurda in PLA case number 35/2020, but have admitted and agreed to pay the amount of rupees 6,72,742 in the WS. Sir, etire jo amount carefully listen. 6,72,742. That upon deposit kar do nanti.
Yes, lordship director then will be fine. He is not agreed.
Let him not agree. Upon 80 deposit kar do.
Yes.
ठीक ଅଛି. ଖୋସାମତ କରିବା ଦରକାର ନାହିଁ. ସେ ଯଦି ନେବେନି ଆପଣଙ୍କ ତା ପଛରେ
earlier he has provided for the account number of the SBI account number. We were requested to try to deposit that amount, but that amount already closed. That was also mentioned in our written statement also.
ଏତିକି 6,72,742 issue notice to the opposite party by speed post with registration and proof of delivery requisites for issuance of notice shall be filed within, opposite party?
No, one person.
Shall be filed within three working days or 5? Postal requisite कितने दिन दे परिवे?
Within 7 days.
Within 7 working days. Stop. In view of the statement made that the present petitioner have agreed for an amount of rupees 66,72,742 in the written statement filed by them before the PLA, the said amount shall be deposited before this court through a demand draft in the name of the registered judicial to the credit of the present application. Stop. The amount shall be invested in a high interest yielding fixed deposit in आपको स्टेट बैंक भल लगे नहीं?
State Bank.
Yeah. You like State Bank or I'll direct other bank?
We are the associate of the SBI General Issue, the associate of the
Invested shall be kept in the State Bank of India. Odisha High Court. Right. With auto renewal clause. It is further directed that the operation of the judgment dated Amoka passed by PLA in so and so case shall remain stayed till the next date of hearing. Returnable date be fixed to आज कितने तारीख हो चुकी आपण आन करिवे 27 anyway. Returnable date be fixed to 14/7/2026. The matter shall be listed for orders for orders in the week commencing 27/7/2026. The personal appearance of the officer present is dispensed with. Yes. And you please apprise the officer that how much the lawyers and the judges are working for arriving at a settlement. So I have cited all 3 decisions because Supreme Court has said Lok Adalat, a lot of effort is made. Now there is direction of the Supreme Court. We are encouraging that. And pre-Lok Adalat mediation, the sittings and all that. So after achieving something, suppose you have not agreed as you have said, nobody can force you. Correct? But if you have achieved something by a lot of efforts, your own efforts, the officers' effort, they visit, sit with us, we say, ask them questions, they brief us. After that, it should not be wasted like in one line by challenging. Yes.
Item 5.
Mr. Samantra will appeal this case.
It's specific mark till 12th. से कॉल कले 5 कॉल कर
मतलब item 5.
वो अपन 5 ने 7 कर 7 शुगला ओके
Item 5
5
I pass for Mr. Samantra will appear.
Number 6 Lochon number.
Item 6.
May I please, your lordship?
Yes.
There are two wives petition for transfer
Yes.
from the court of the Judge Family Court Sanpur to the court of London Judge Family Court Balangir. Husband had filed a petition at CP number 1 of 2026. There are 2 other proceedings are also pending at Balangir.
So how many criminal cases the wife has filed?
That 1 maintenance case before the London Judge Family Court Balangir and 1 criminal case.
So that is not a ground. Any decision on that? That wherever the wife chooses to file criminal cases,
No, that is, my lord, one coordinate bench has
the
been.
coordinate bench that Supreme Court decisions are there. Very good. Supreme Court decision.
Supreme Court NCB Aishwarya versus AS Sarvana Karthik को rely करके देइचंदी जे other टा भी अछि and he is a destitute lady miller. He is unemployed.
So did you read this Aishwarya versus Sarvana?
Lord, I have not read.
Please do.
Great respect, I have not read, Miller.
Oh, you have to respect Supreme Court.
My lord.
Sarvana टा देले स्टेट अछि नहीं ठीक है.
In same case of
Sarvana is directly against you.
My lord.
Sarvana, Aishwarya files a 125 application and a section 9 application at Chennai.
My lord.
Here, this lady has filed a 498A and a 125. Please appreciate that. And in Vellore husband filed 13.
Like my
That
value.
is how the Supreme Court says that both 9, 13 and 125 because of Rajneesh versus Neha also.
My lord.
But your case, can the family court try 498A?
No, my lord. Only maintenance.
So obviously, so that is not that is how.
And the husband has filed.
That is how that one line in paragraph 7 has to be read with earlier paragraphs of
My lord.
Aishwarya versus Sarvada.
My lord. Here the husband has filed, my lord, divorce proceeding at Sonpur.
Have you filed section 9? Do you want to continue with the matrimony?
My lord.
Have you filed section 9?
No, wife has not filed.
So then, however, Aishwarya has filed section 9 in Chennai.
My lord.
Actually, Aishwarya versus Sarvana is not on that point. But problem is that then comes, have you read Queen versus Latham?
No, my lord.
The judgment is authority on what logic, what it decides, not what logically follows from it.
My lord.
So I cannot rely on Aishwarya versus Sarvana and grant you that relief because Queen versus Latham stares at me.
My lord.
That is not the proposition laid in the Supreme Court says in our social paradigm, the convenience of the wife is to be looked at.
Looked at, my lord.
That is the language. What you have not read, that is the
My lord.
language.
Read-
There the Supreme Court has highlighted that she
My
has
lord.
filed section 9.
My lord.
She has a child and she stays with her parents.
My lord.
Then section 9 and 13 have to be taken up. But you have filed a 498A. I cannot direct that to all three to be taken up.
No, not all. If it will be transferred, my lord, it will.
So your Sonpur and Balangir being so nearby, 125 will be transferred to Sonpur, Balangir.
No, 125 ଟା ବଲାଙ୍ଗୀର ଅଛି, my lord.
ଯୋଉଠି ହଉ
Wife.
ସେଇଟା ଛାଡି ଦିଅନ୍ତୁ ଆପଣଙ୍କର ଯୋଉଠି ଅଛି 13 ସେଠି 125 ଟ୍ରାଏଲ ହବ.
My lord, that will be not the convenient place because I have been tortured, my lord. I have been
High Court ରେ କେହି ଟର୍ଚର ହୁଅନ୍ତିନି.
driven out by my matrimonial home. Thereafter, I am residing at
So
my
Sandra, you
parents'
must
home.
understand that I have to say that since Balangir is a torturous place, Sonpur is a better place, I cannot say that. ସେଇଟା ଆପଣଙ୍କ କ୍ଲାଏଣ୍ଟ ଆପଣଙ୍କୁ କହିଲେ ଆପଣଙ୍କର ଓଟ ଆଉ ଓକିଲ ତ ମୁଁ କହିପାରିବିନି ନା. And Balangir and Sonpur, they were in fact only one judge seat. They are the closest possible judge seat in Odisha.
My lord.
So that logic is not correct. Tortured by wife, torture of the wife by the husband and his family cannot be a ground to say that this court is better for tortured wife and that court is not. That's the problem. I'll pass that order. Take adjournment.
My lord.
I'll adjourn it because you are saying that there's a possibility that though you have not read Aishwarya versus Sarvada, my difficulty is that I have read Aishwarya versus Sarvada. I have read Queen versus Latham. I cannot pass that order. I cannot misinterpret a Supreme Court judgment.
Your lordship may urgent, I will go through these judgments. And
No, I'll pass that. You rely on your citation, I'll say, but my observation because one of our young colleagues, very young, she has researched on this. She presented that, but I have presented her to read Queen versus Latham.
let one chance may be given, I will go through these judgments.
No, I am not disposing of that.
My lord, my lord.
None of the matters I am disposing of except where I find that it's a strategy to delay payment of, because neither you are paying the maintenance,
My lord.
you are neither here nor there. Amega Dabunu. Amega Dabunu, High Court cannot be a party to that.
My lord. My lord.
You should not be also, because you are at a much higher level. The judgment would have got a point. Hold on. नहीं हो चुकी ତମେ ଉଠିଲା ପରେ ମାନେ ଏପଟ ସେପଟ କି ଏଗୁଡାକ ଏପଟ ସେପଟ କିଏ କରୁଛି କାଲି କାଲି ଲାଷ୍ଟ ମ୍ୟାଟରରେ ଯୋଉଟା ଥିଲା ମାନେ କାଲି ଥିଲା ପଳେଇଲା ପଳେଇ help it ପୁଣି ଗଲେ ସେପଟେ ଯାଇକି ସେଇଠୁ ଆଣିଲେ ଥୁଆ ହେଇଥିବ ସେ ଗୋଟେ ବକ୍ସଟା ଦିଅ ଏଠି ଜଜମେଣ୍ଟ ଉପରେ ଯେତିକି ଅଛି ସେଇଟା ଦିଅନ୍ତୁ ତାକୁ ଆମେ ସେ ଜଜମେଣ୍ଟଟା ଦିଅ ରଖନ୍ତୁ ये जो जजमेंट एट ଥିଲା ଆଲଫ୍ରେଡ ମାରିଟାଇମ୍ ଆଣ୍ଡ କ୍ୱିନ୍ ଭର୍ସେସ୍ ଲାଟିନ୍ ସେଟା କୁଆଡେ ଗଲା why after I rise all this being displaced no then क्वीन भर्सेस लाटिन कुआडे गला नहीं बर्तमान किसी आनिया दरकार नहीं This was the way to conduct AR ऐश्वर्या वर्सेस सर्वना तार AR साइटेशन पे दरकार नहीं बर्तमान दरकार नहीं कोर्ट को अपेक्षा करें वेस्टिंग लॉट ऑफ टाइम
But will also
the petitioner apparently the petitioner before this court is the husband in the marriage sorry wife in the marriage she seeks a transfer of the CP number 01 of 2026 filed by the husband in the marriage pending before the Learned Judge Family Court Sonpur to the Court of Learned Judge Family Court Balangir. Now, the grounds as stated for seeking transfer is that the wife has lodged FIR against the husband and his family under sections 85, 298, 115, 2, 351, 3, 89, देखिए लिखिए page 19, which are pending. Charge sheet has been filed
no, my lord.
before the
Town police station. Bala.
before the town police station Balangir, and it is stated that also an application under section 125 CRPC has been filed before the Learned Judge Family Court Balangir. 125 magistrate का पाकर फाइल कर ना कोई
नहीं, family court my lord under section 144 of the BNSS.
Oh, so application has been filed under section 144 of BNSS before pending before the Learned Judge Family Court Balangir. The Learned Counsel relies on the decision rendered in Aishwarya versus Sarvada, reported in AIR 2022, Supreme Court 4318. The result of the said judgment indicates that the apex court has not laid down that wherever the wife files FIR against the husband, the petition filed by the husband under section 13 has to be transferred. In Aishwarya versus NC in N.C.V. Aishwarya versus A.S. Sarvana, the facts as noted by the Honorable Apex Court is that the wife had filed application under section 9 of the Hindu Marriage Act for restitution of conjugal rights, as well as application under section 125 CRPC seeking maintenance before the court at Madras, at Chennai, Madras or Chennai, at Chennai. The husband had filed application under section 13 of the Hindu Marriage Act at Vellore. The place of residence of husband and the solemnization of marriage was at Vellore. The High Court of Madras rejected the prayer of the wife under section 24 of the CPC seeking transfer. Paragraph 9, 10 and 11 from Manupatra print from NCV Aishwarya Sutra is reproduced here. In the case at hand, in the present case, the wife has initiated a criminal proceeding by lodging FIR which cannot be tried by the family court. Further, section 9 of CPC, section 7 of the Family Courts Act, section 17 of the Hindu Marriage Act, read together, would lead to a irresistible conclusion that the place of filing of the petition under section 13 of Hindu Marriage Act is within the territorial jurisdiction of the said court. Regarding location of both the courts, Balangiri and Sonpur were part of the same jurisdiction under one district judiciary, and after division they are adjacent. So, the Lord Counsel for the petitioner has adjournment. The matter shall be listed for fresh admission in the week commencing 13/7/2026. देखो अपन नोटिस पाइला परे चली आसले ठीक
My lord.
conciliation केमती होबो जाय
Lord.
the mandatory conciliation if the
Correct.
High Court transfers it, how it will happen?
That will appear, I mean, like, if he also appears, we will also try for conciliation here.
କାଇଁ appear କରୁନାହାନ୍ତି ସେଟା ତ ଆପଣ ସେ High Court चले आसले कहले बंद करंतु सेठी बोली. The entire scheme of Family Court Act is frustrated by exercising transfer and this jurisdiction. And the concern of Supreme Court that all three cases to be tried together has been conveniently forgotten by you and looking at it. Of course, you are saying that I have not read.
My lord, my lord.
To be fair with you.
My lord. And because my father is also dead, my lord. No one is there. I have
Sir, where
resided
is
with
that
my
provision? that for dead persons, only one court, nearest next door neighbor. Just imagine in Bhubaneswar, the traffic condition, if one travels from Mancheshwar, he reaches Cuttack in 30 minutes. And if he reaches the High Court at the District Court, it will take 1.5 hours. So you must understand the logic also. Stretching the logic is this problem. Both are good places and both are adjacent places. Next date केबे अछि?
Let appearance by
आपण adjournment नेबे हो ठीक अछि.
Hello.
Sure नो दे adjournment नेबे जा करले.
let IA will also say I pray for adjournment there for appearance.
IA 159 of 2026. तापर लिखि देबे Queen versus Latin ऊपर. पैराग्राफ तो अच्छे अल्फ्रेड मैरिटाइम के. तापर IA number 1590 of 2026. In view of the adjournment of the matter, in view of the adjournment sought for by the petitioner herein, the Lorded Council requests for seeking adjournment before the Lorded Judge Family Court, Sonpur. Stop. Accordingly, in the interim, it is directed that the CP number 80 before Lorded Judge Family Court, Sonpur shall be adjourned. Upon केबे date तारीख कर देले? Shall be adjourned beyond 20/7/2026 upon a prayer being made for the said purpose. To a date convenient, as would be convenient to the learned court in season of the matter. Yes, next please.
Grateful, madam.
Yes, please.
Pachor item 5.
Mr. L. Samantara,
under section
on behalf of
407.
along with Mr. Vedaprakash Panda for the petitioner.
No,
Mr. Abhilash Misra. Mr. Abhilash Misra for the petition.
I am for the statement.
Mr. P. N. Lenka, AGA for the state. The appearance memo of the Lorded Senior Counsel for the petitioner shall be taken on record, scanned copy be updated. On the yes.
In this case,
Yes,
seek transfer of the sessions case from Pallakhamdi to Barampur on the ground that let's say an unknown FIR was registered by the behest of the secretary of the Pallakhamdi Bar Association that one of the members was attacked by way of throwing of acid on his face and body. Subsequently, the petitioner and others were
Instruction niyantu. Say hostility of the bar kouchanti.
बात नहीं है, दीजिए प्राइवेट नोट ये लॉटरी में
for state for OP1. The petition has been filed seeking transfer of ST case number 41 of 2025 from the Court of Sessions Judge Gajapati at Paralakimundi to the Sessions Judge Berhampur, which is the neighboring district of Gajapati. So, it is submitted by the Learned Counsel that the Learned Senior Counsel that the petitioners are in jail custody, are in judicial custody, in sub-dash jail Paralakimundi, district Gajapati. As the allegations revealed in the FIR, the two unknown assailants attacked P. Ramarao, a practicing advocate of Paralakimundi Court, member of the Paralakimundi Bar Association, at about 4 to 4:30 p.m. on 9/11/2024. It was a acid attack. The victim suffered grievous injuries, and luckily he survived. Final form has been submitted under BNSS 2023 under sections. A final form has been submitted under sections
No, sir.
121, 109, 3 3 into bracket 5 of Bharatiya Naya Sanhita, BNS, 2023. The petitioners are facing trial. Being in custody from 2/2/25, the charge sheet was submitted on 2/5/25. The petitioners apprehend their safety as well as whether the court can proceed in a the Lorette trial court can proceed in a manner without any interference. Stop. Some specific instances are mentioned in the paragraphs 7, 8, 9, 7 to 10, 7 to 10 of the petition. Stop. Issue notice to the opposite parties. Issue notice on the question. Issue notice. To the opposite parties, the learned AGA upon advance copy served appears on behalf of OP number 1 and waives notice. He shall obtain instruction in the matter regarding transfer of the matter. It will issue notice to the OP number 2 indicating that the matter is likely to be disposed of at the stage of admission. Returnable date be fixed to
Odisha.
Returnable date be fixed to 14/7/2024. The matter shall be listed for orders in the week commencing 20/7/2024. Liberty to mention. The learned senior counsel, being leader of the bar, the Odisha High Court Bar Association. I know you have been smart that way. Both the learned senior counsel for the petitioner, along with the learned counsel representing the petitioner and the learned AGA, are requested to explore the possibility of arriving at a identifying the place of trial, which will be agreeable to both the complainant, the prosecution, as well as the accused.
Copy of
But I never.
Not on board.
I asked.
Before the learned judge, if learned court in session of the matter, ST case number 41 of 2025. Pending before the session judge Gajapati at Paralakhe Mundi shall be adjourned upon a 20 तारीख को रखिले 20 shall be adjourned to a date beyond 27/7/2026 as would be convenient to the learned court in session of the matter upon a prayer being made for the state purpose. It was the case of complete circumstantial evidence. That is how he got acquitted.
Right, sir.
Yes, Mr. Misra, Abhilash Misra. आइए कुछ चुन आइए फाइल करी आज अच्छा लिखिए लाइन ऐड कर दियो it is submitted by the learned instructing counsel Mr. Misra that IA has been filed in court today, copy of which shall be served on the learned AG and shall be presented before the court during course of the day. तापर ऑर्डर टा लिखिए आनी की दे देबे तुम
Okay.
सर्वे कॉपी और मिस्टर लेंक
Yes, ma'am. Well,
yes. Yes, next.
Item 8.
Mr. A.K. Ponda for the petitioner. Yes.
The petitioner is the wife. She has filed this case seeking a direction to the learned judge family court Bhubaneswar for a early conclusion of the execution proceeding. It is pending since 2024.
To look, I will be looking foolish, sir. Already Rahul Shah and Periyamal Supreme Court has issued guideline.
On the basis of
So
that
you
guideline,
appraise the court.
frequently adjournments are being granted to the opposite party for payment of maintenance.
I guess it has court ko apon chance diontu. Court is aware of.
Well, also, you observe that.
How can, sir? I should not. How can you say that the senior most judge of the district doesn't know law? Must understand, family judges courts are senior than the district judges. Many places. I cannot say about Bhubaneswar. And this is larger than decision. Rahul Shah, how to deal
Yes.
with a execution case?
I'm aware of that, but I have given the order sheet.
Have you appraised the court? The
No.
question to you that is my concern to express to you. What appraise karantu? Then the court may say something about what application to the
Right.
How pain is matter than showed.
Right.
At least the other party will be aware. They may not be aware that they think that it can be adjourned. It cannot be adjourned.
Yes.
Rahul Shah, I think it is 6 months.
Yes, 6 months.
The learned counsel for the learned counsel for the petitioner. The petitioner before this court is the wife in the marriage. She has filed execution petition number 67 of 2024, and it for the execution of the judgment dated
Recovery of the maintenance amount for the order dated 12/1/2024.
12/1/2024. This in CRP number CR.P. number 208 of 2022. The learned counsel for a prayer लिखिए तापर कमा देख लिखिबे she seeks for a direction for expeditious disposal of the execution proceeding. The learned counsel for the petitioner is apprised of the decisions of the Honorable Supreme Court that of the Supreme Court larger bench in Rahul Shah versus so and so, as well as Periyamal, wherein elaborate guidelines have been issued by the Honorable Supreme Court under Articles 141 and 142 of the Constitution of India. The said judgments have been circulated throughout the country to be followed by everyone. So, the learned counsel shall apprise the learned court to do the needful. The petition is disposed of.
No.
Rest of the matters after recess, Mr. Mishra, Senior Mr. Mishra.
21.
21, I'll come back after, or you want, both sides are present.
Must be present.
After lunch.
After lunch, sir. ठीक है जी.
Paragraph 5, last one.
Next week, because the problem is this adds to the pendency. Nothing is going to happen. Only the discussion will be that so many matters are pending before High Court. Because this can't be decided by this court. Even if you deny your liability, you have to challenge denying your liability before the appellate court.
My lord may condone the delay and I will approach the.
Sorry?
If my lord may direct to.
No, I understand because I have told you that before you told the court that let the delay be condoned while discussing with Mr. Ray, I said that I will condone the delay.
Then my lord.
Because statutory condonation is not possible. Even I am not sure whether I have power. But still, exercising 226 jurisdiction, I'll condone the delay. Considering your submission that you are not aware of the order. Do you want it today or next week?
Well, let's make pass on.
Mr. P. Mahanti for the petitioner. Mr. Amarendra Prasad Ray for the opposite party. The lauded counsel for the petitioner was asked to serve copy of the writ application on the lauded standing counsel appearing for the opposite party ESI Corporation. Stop. Comma. Accordingly, copy of the application is writ petition is served on the lauded counsel for the opposite party. Stop. The petitioner is a partnership firm or a proprietorship firm or what?
My lord is a proprietorship. Proprietorship concept.
The petitioner is a proprietorship firm
Engaged in construction.
engaged in
Constructions and engineering related works.
engineering in construction and engineering. Is before this court seeking intervention under Article 226 and 227 of the Constitution of India, challenging the garnishee order dated 16/2/2026 into bracket annexure 1 of the writ application under section 45 capital G of the ESI Act dated 16/2/2026 passed by the recovery officer. Stop. Also under challenge, the order dated 29/12/2025 into bracket annexure 3 issued by the Deputy Director cum authorized officer ESI Corporation whereby the petitioner establishment has been directed to be covered with effect from 1/12/2011. Stop. ESI Act पढ़ेंगे. पढ़े.
वही अच्छी मिल
ଏଇଠି ଅଛି ଯେଠି ଏଠି ଆମର ବହି ବ୍ୟବହାର ହୁଏନି ତେଣୁ ମୁଁ ଏକ୍ସଟ୍ରା ବି ରଖିଛି ସୋ ଦ୍ୟାଟ୍ ଦବା ପାଇଁ कौन लिखले रिकवर्ड नो आगे कवर्ड को अपन रिकवर कर under the provisions of the act. It is submitted by the learned counsel for the petitioner that the petitioner is aware of any proceeding. कौन कोर्ट aware नांती बोली कहउछंती आगे which you are not aware because you have annexed both of them.
I am not aware of the 45 proceeding under 45A where the determination
The petitioner is not aware of the 45A proceeding that was undertaken by the authority or initiated by the authority as the petitioner as it is contended that the petitioner was not served with any notice. Stop. The learned standing counsel referring to appeal provision ta kota hai
Section 75, my lord.
section 75 of the
75(1) subsection G re jibe.
75(1)G
My lord.
75(1)G of the ESIC Act मिल आपण Good. (75)(1)G submits that the petitioner has to approach the employees insurance court for challenging the orders which is sought to be challenged in the present writ application. 75(1)G for convenience of reference. The section 75(1)G is reproduced here. With 75 into bracket English 1 into bracket small g. The limitation da?
My lord, 77(1)A.
The learned counsel for the petitioner refers to the section 77(1)(A), which provides thus.
My lord, dash no running. One side re capital A.
dash আছে আচ্ছা factory dash it like
को भाई को कंपनी वही से
ये हमरो
को पब्लिकेशन
एटा होचे हमरो दी लॉ पब्लिकेशन
जेते भूल करंतिनी but never change the structure of the section. One dash capital A.
Right.
(77)(1) or 1A quote करते हैं. The said provisions are sorry the standing counsel refers to 77(1) and 1-A and submits that the application has to be made before the ESI court. ESI no. EI court, Employees Insurance Court. Employees माने S for apostrophe. Employees Insurance Court. Employees plural, proper apostrophe. Within a period of 3 months from the date.
3 years, man.
Within a period of 3 years from the date on which the cause of action arose. In the present case, the cause of action arose on
March 2013.
March 2013. But the problem is that your letter is 25. How can I say 2013? 13 to kichi nine document.
No, my lord. In that order, third paragraph, my lord.
Yes.
The above named factory establishment and its principal employer were and are required to pay sum of such and such.
সেটা তো আপনার পেমেন্ট কথা কହୁଛନ୍ତି কজ অফ আকশন ଆପଣ ଯୋଉ ଦିନ 25 ମସିହା ପର୍ଯ୍ୟନ୍ତ ତ ଆପଣ ଯଦି ନ କହିଲେ କି ଲେଟସ୍ ଆସିବ 30 ମସିହା ପର୍ଯ୍ୟନ୍ତ ନ କହିଲେ କଜ ଅଫ ଆକଶନ ଆସିବ କେମିତିଆ
That is run from the order, and this notice preceded by that followed by that.
Because if I have understood correctly, that you are saying in 2025 that he is covered from 2013.
No. Order must have been passed.
Why say that?
The order se karinahanti kହୁଛନ୍ତି ଆମେ ଜାଣିନୁ ବୋଲି.
ନା ପଞ୍ଚତି ଭବନରେ ସେ କୋଉଠି ଆସିବେ? ପଞ୍ଚତି ଭବନରେ ବସିଛନ୍ତି ଆପଣଙ୍କର ନବନୀତ କେ ନବୀନ.
My lord.
Navneet K. Naveen does not refer to any order. That is the question to you. ତାକୁ କେହି ମୁଁ ପଚାରିବି. Navneet K. Naveen ଏଟା କୋଉଠୁ ଆଣିଲେ?
This is, my lord, for application for recovery.
Correct.
And this application
based on the ଆପଣଙ୍କର even para 6 ରେ ବି ଆପଣଙ୍କର recovery officer ଯିଏ କରିଛନ୍ତି authorized officer,
my lord,
he doesn't refer to anything of 2013. ସେ କହିଲେ the factory has been provisionally covered with effect from 1/12/2011.
My lord.
Where from he gets it? Because suppose he is a recovery officer.
My lord.
He will refer to license, notification.
No, this is not issued by the recovery officer, my lord. This is issued by the authorized officer.
Recovery ଟା ମୁଁ ଭୁଲରେ କହିଲି, ଥରେ ତ କହିଲି ନବନୀତ କେ ନବୀନ, ମୁଁ ସେଥିପାଇଁ authorized officer ବି କହିଲି.
My lord.
ଯୋଉଦିନ authorized officer ଏଟା issue କଲେ, on what basis he is deciphering that?
My lord, that is 45A order. Basis of this application is 45A
order ଟା ଦେଖନ୍ତୁ ତାହେଲେ 45 order କାଇଁ
45 order से challenge କରିନାହାନ୍ତି କି annex ବି କରିନାହାନ୍ତି, ସେଇଟା ହଉଛି କଥା.
କଣ ଲେଖିଲେ? କୋର୍ଟ ହେଇଗଲା, କୋର୍ଟ କର. Now looking at the amendments made in the writ application as well as the annexes, it can be seen that the order 45 or the order passed by the authority under section 45 of G of the ESI Act has not been annexed. 45
A capital A.
Upon G 45 capital A has not been annexed. The order dated 29/12/2025 though states, quote, page 21 देखिएगा, the factory establishment has been provisionally covered with effect from 1/12/2011. At paragraph 6 and also refers to the period starting with March 2013 at paragraph 3. But the said order by the authorized officer does not refer to any earlier order or any other document to observe that the petitioner is liable from March 2013. The garnishee order into bracket annexure 1 dated 16/2/2026 passed under section 45G. Have they referred to anything?
No, my lord.
Also does not refer to any prior order.
Only two certificates.
Nor the order passed in 45A.
My lord.
Stop. In such scenario, from which date the 3 years can be calculated as prescribed in section 77. Becomes a nebulous issue. Stop. In the interest of justice and fair play, and exercising the jurisdiction conferred under Article 226 of the Constitution, this court is of the considered view that since the date of cause of action as prescribed in section 77 is not very clear, the petitioner shall approach the ES court,
Employees Insurance,
EI court, Employees Insurance Court, पूरा डाल लिखिए, by filing appeal under
section 75(1)G.
By filing application, appeal लिखिए, application under section 75(1)G within a period of 4 weeks, within a period of 6 weeks, which shall not be extended. The learned EI court, that is
Jagat Singhpur. Jagat Singhpur.
designated Ganchandi.
District Judge come Employees Insurance.
The learned district judge come employees insurance court having jurisdiction shall consider the application under 7675 into bracket 1 into bracket small g on merits without detaining itself for considering condonation of delay in filing the appeal. Filing the application. Stop. This court puts on record the contribution, the contribution of the learned standing counsel for early disposal of the matter in view of the fact that the petitioner alleges that he is not received of copy of the order 45A order. 45A order. Stop. The petitioner shall make application of all such documents before the authority within a period of
2 weeks.
Within a period of 10 working days. The authority shall provide them the copies, authenticated, public certified copies, as per the rules within a period of 7 working days thereafter. Right? After 8 period tak 8 weeks करदु. आपण 10 days रे मागंतु से आपण को 7 days रे देबे working days of course. तापर आपण फाइल करंतु. The parties shall have liberty to raise all contentions. The petitioner as well as the opposite party shall have the liberty to raise all contentions before the learned EI court. It is further clarified that this court has not expressed any opinion regarding merits of the case of the petitioner or the contentions of the parties in any manner whatsoever. Yes.
My lord, without mentioning my submission, my lord may say, as my learned friend is submitting, entire amount is recovered. My lord may say 77 2B may not be 75 2B may not be come.
Shall not deter itself. It is submitted by the learned, as it is submitted by the learned counsel for the petitioner and stated in the writ application. Appropriation
appropriation.
The learned counsel for the petitioner upon instruction that the entire amount directed by the authority has been appropriated from his bank account. On Quebec date delivery.
Yes, my lord, I have brought it in the memo.
The memo as indicated in the memo filed today, which is taken on record. Amount होची 8,58,880 appropriated on 11/3/2026. The appropriation of the said amount by the opposite party authorities shall be subject to the further orders of that to be passed in the application. Stop. Is further directed. Since the entire amount has been appropriated, section 75 into bracket 2-B capital into bracket 2-B bracket closed shall not be barred in any manner which prescribes for deposit of 50%.
Deposit term pre-deposit before filing of the application, petitioner is required to deposit.
That this court exercises the power of This court further takes note of the proviso to section 75(2) B, which gives power to the court for power to waive or reduce the amount to be deposited. In the present case, as indicated in the memo filed by the petitioner, the entire amount has been appropriated.
Master.
Memo copy ta deବାକୁ ପଡିବ
हाँ दे दी कथा डबल
Yes, yes. সেটা পুরোটা নিয়ে যাও Yes, next.
Item 11. My lord, in this case, 2 IA has been filed, one for continuation of delay and another for stay of the impugned judgment, my lord. In by order dated, my lord, 8/5/2026. Yes, execution has been filed. And also,
Mr. Prem Kumar
my lord, already your lordship in connected matter, this order has been passed now.
You have already appeared, Mr. Pradhan. Yes, yes. Mr. Vishnu Prasad Pradhan for the opposite party. Good. ତାଙ୍କୁ ଗୋଟେ ଦେଖାନ୍ତୁ Mr. ପ୍ରଧାନଙ୍କ କପିଟା ଅଛି ଆପଣ କନେକ୍ଟେଡ ମାନେ ଏକା ଲ୍ୟାଣ୍ଡ କହୁଛନ୍ତି ଆପଣ
Yes, my lord. All,
କେତେ ଦିନ ଡିଲେ
this is 120 days delay.
ସେ ଲ୍ୟାଣ୍ଡ ଲୁଜର ତାଙ୍କୁ କିଛି ପଇସା ଦିଅନ୍ତୁ ଆଜ୍ଞା ସେତେ କେତେ ଟଙ୍କା ଆପଣ ଗୋଟେ ଦେଇଥିଲେ
500.
500 ସେ ପ୍ରଧାନ ଆପଣଙ୍କ ପୁରୁଣା କ୍ଲାଏଣ୍ଟ 5 ଟଙ୍କାରେ ରାଜି ହେଇଯାନ୍ତି and after Supreme Court decision that
Yes,
60 plus 60 that theory perhaps Supreme Court has taken care of course you are the land loser आइए এটা ଆପଣ ଦେଖି କରି ଦେଇ ପାରିବେ the IA has been filed by the appellant under section 5 of the Limitation Act seeking continuation of reported delay of 117 दिन
120 days.
ସେଥିରେ 120 ଦିନ ଥିଲା ଏଇଟାରେ କେତେ ଦିନ
No, it's 120 days.
ସବୁ ସମାନ ଫାଇଲ କରୁଛନ୍ତି
ନା ନା ନା
No, no,
No, no.
different, but
ଆଇ ଥିଙ୍କ ଏଇଟା 176 ଯାଇ ଯାଉ
no, no.
ମାନେ
I'm-
ଦେଖିନାହାନ୍ତି ରେକର୍ଡଟା ଦେଖି କହୁନାହାନ୍ତି
Record I have seen it is not
ଦେଖିଥିବେ।
120.
reported delay of 120 days
ସେଇ ରିପୋର୍ଟେଡ କେସଟା 120
Yeah, sir, report will.
reported delay of
120
120 days in filing the appeal ତାପରେ 1 2 ହେଲା IA 206 ଯୋଉଟା ଅଛି ସେଟା ରିପ୍ଲେସ କରିଦେଲେ IA 200 224 ନା
ମତେ ଲେ 24
हमें calculate करना है स्टाफ report.
3 ଏଇଟା କଣ ଆଗରୁ ନୋଟିସ ଇସ୍ୟୁ ହେଇଥିଲା
No.
ଆଜ୍ଞା
Yes.
ତାହେଲେ ଆପିଲ ସେ କେମିତି କଲେ it is para 2 ରେ ଗୋଟେ ଲାଇନ ଆଡ୍ କରି ଦିଅନ୍ତୁ para 2 ଟା ଯାହା ରିପ୍ରୋଡ୍ୟୁସ କରିଦେବେ ଆଡ୍ କରିବେ it is submitted by the learned additional standing counsel that for the appellant state that the issue regarding continuation of delay beyond 120 days to bracket 60 plus 60 has been authoritatively decided by the Honorable Supreme Court. By judgment dated 9/2/2026. Now what separate lecture to insert कर दो. In view of issue notice करिवे तापर para 3 ट पर 4 issue notice. In view of appearance of learned counsel for the respondent, no further notice be issued in the IA as well as the appeal. आपण IA copy पाइना मिस्टर प्रधान
हाँ
Copy of the IA and the appeal memo has been served on the learned counsel for the respondent. Stop. Considering the grounds stated in the IA supported by affidavit seeking condonation of delay and applying the principles indicated in the Deputy Commissioner and Special LAO versus Messrs. S. V. Global Mills Limited. Colon 2026 INAC 138. The reported delay of 120 days is condoned subject to payment of rupees 500 to the respondent within a period of
15 days.
Within a period of 15 working days. So, appeal IA is favored and disposed of. I had a lie over upon debate of appeal. Subject to payment of cost and condonation of delay, notice be issue notice to the respondent. Stop. In view of appearance of learned counsel and the copy of the appeal memo having been served to further notice be issued. Stop. The matter shall be listed for orders in the week commencing 27. In the interim, it is directed that the judgment dated 28/12/2023 passed by the learned presiding officer, LAR and our authority from a Northern Division, Sambalpur, in LA case number 258 of 2022 shall remain stayed till the next date of hearing. Yes, next.
Item 12.
44 at sent.
12, 13, 14.
The only
limitation
period is different, my lord.
हसी देखी कि आपण करिवे 12 रे हैला 120 ने 11 रे 120 12 भी 120 13/77 14 reported delay of 77 so between apparent समान रहतो आईएटा डिस्पोज ऑफ हैला अपरे अपन स्टेट आ जो जोटा स्टेज जोटा हैला नहीं এটা ওটা আইএ আছে আইএ রে অর্ডার of আইএ রে লিখিবে the copy of the IA has been served on the learned counsel for the respondents opposite party so after in the entry আইএ से এটা ডিসপোজ করতে হবে ডিলেট আইএটা ডিসপোজ হয়ে গেল এন্ট্রি মডেলটা ডিসপোজ হলো আপিলটা রইলা yes
13, 14 also. Sir.
Yes.
15. पासवर्ड कौन को 3टा भाई मेंशन करी ना 15 की मेंशन कर दिले 15 petitioner done opposite party none the matter is listed for orders. Would have further opportunity list in the week comment list. The matter shall be listed for orders in the week commencing 6/7/2026. Call करो तो जल्दी
17
16 ना 17 16 कौन डका है ची
Pardon, madam.
Yes.
15.
yes
But I'm there for the opposite party.
15 petitioner आपण तले petitioner none Miss Mehta Ayushi Mehta for opposite party A Mehta for opposite party 6/7
Report.
16
16.
In item number
Yes, sir.
16.
Hon'Ble Roy Chaudhary for the petitioner. So, ଆପଣ for the
I am for
OP.
Yes.
ନା ଆପଣଙ୍କର?
Sanat Sushohan Panda for opposite party.
Mr. S.S. Ponda. 16, Mr. Mahanti, you are there.
Yes.
State. Mr. Prem Kumar Mahanti for OP1. Mr. S.S. Ponda for OP2 and 3. Stop. IA 9373 of 2026 has been filed by the petitioner with the following prayer. So, the writ application has been filed challenging order dated 9/12/2023 passed by the learned civil judge senior into bracket senior division bracket close Jajpur in CS number 1056 of 2023. Stop. In view of the prayer made in the IA, the writ petition is disposed of. Copy of this order shall be forwarded by the registry to the so and so court to be kept in the records of so and so. Yes. Yes. Next. Petitioner done. IA 18 of 2025. The stamp report dated 3/12/2024 indicates at paragraph at entry 9 that correct nomenclature is single quote MATA. The IA has been filed, though no one is present to move the same for conversion of the application from RPFAM to MATA. Stop. In view of the stamp report, prayer made in the IA is allowed. IA is favored and IA is disposed of. Stop. Registry shall do the needful for change of nomenclature of the application from RPFM to MATA. Stop. Copy of this order shall be forwarded to the learned counsel for the petitioner by the registry. Stop. Yes, the matter shall be listed before the assigned bench. Yes. The petitioner shall have the liberty to move the assigned bench for listing of the matter. Next.
19.
Yes.
I'm on behalf of petitioner, so I pay for the adjournment.
ଆପଣଙ୍କ ନାଁ?
Lipsa Mudra Swai on behalf of Lingaraj Sadange.
Lipsa?
Mudra Swai.
MS Lipsa Mudra Swai on behalf of L. Sodangi for the petitioner. But this is again for conversion. So why you are moving adjournment?
So actually, my senior is not.
You talk to, I'm passing it over. You talk to your senior. This is a best case, you should start arguing. Simple prayer.
So
look at the brief.
So he is not here.
Sorry? But my order has to be reasonable or not?
Yes.
Even an IA seeking change of nomenclature, should I adjourn? Pass an order of adjournment? Can you not talk to your senior? Or anyone from your chamber?
No one is here.
Phone ray. These matters should not be, this is listed for order, should not be adjourned actually. Just go out and talk over mobile phone. Because when they instructed you to adjourn the matter, you should have looked at the cause list, looked at the brief, what prayer you will make. That would have helped you. Talk over phone and come back. Okay. Passed over. Yes, next. Call karo to agya kon apno posi gale.
Item 20. .
None appears for the petitioner when the matter is called. IA order lectundi. IA 131. The IA has been filed for conversion of for change of nomenclature of the petition from RPFM to CRLMP. No one is present to move the application when the matter is called. The stamp report dated 3/3/2025 at entry 9 indicates that the application be registered as CRLMP. Stop. Prayer made in the IA has been for conversion of the application from RPFM to CRLMP. Stop. In view of the stamp report, prayer for conversion is allowed. The IA is disposed of. Stop. The registry shall do well to take steps for conversion of the application from RPFAM to CRLMP. A copy of this order shall be communicated to the learned counsel for the petitioner by the registry. Petitioner shall have liberty to move the assigned bench for listing of the matter. Yes, next.
21.
Mr. Surya Prasad Mishra, Senior Advocate, along with Mr. Ramesh Agarwal, for the petitioner, Mr. C. Bairisal, for the opposite party. Listed for orders. Yes, please.
So actually, I have filed an application that summer vacation is approaching fast. Therefore, my application before the passport authority to renew the passport of the child is pending. Now, the authorities say, since the matter is pending before the court, therefore, unless you get a clearance that without the signature of the husband, we can grant it. Law says any one of the spouse can also sign and the passport authority can extend. The reason for extension of the passport is that
So by which order this court has interfered with the proceeding in the passport authority? Is there any order?
Yes, there is an order. Your challenge is passport. Okay. Kindly turn to page 46 of the guardianship GUAP.
Yes.
Proceeding 16 of 25.
Yes. Annexure 3.
Page Annexure 3, I said.
Yes.
The last paragraph, peruse the case record. The relationship between the parties and birth of the son are not in dispute. The major crux of the dispute is whether there is any exigency to allow the petitioner to issue visa.
You are at page 50.
Page 50.
Internal page 4. Yes. Peruse the case record, para 4. Yes.
Para 4, peruse the case record. The relationship between the parties and birth of a son are not in dispute. The major crux of the dispute is whether there is any exigency to allow the petitioner to issue visa in favor of the child being a single parent. The urgency reflected of the petitioner is that the academic session of the petition number 2 has already been started few weeks back. Whereas the opposite party categorically states that since 2021, the petitioner left her son in the custody of opposite party. It is also admitted by both the parties that the child has been studying at Puri since her childhood. Therefore, I do not find any kind of urgency that the pleadings of the petitioner can be well adjudicated only during course of trial. Without going through the evidence, such petition cannot be taken into consideration. He has refused to consider the application. That is why the matter is before your lordship.
Visa, but he refers to visa. He has not referred to passport actually.
So exactly, they are referring to visa. It is without the passport, no visa can be granted.
No, so my questions.
Yes.
Sir, is that if the passport authority is not restrained or in any manner interdicted in considering the passport application, then there is no need for considering because passport is different, visa is different.
I have filed an application here in this court.
So, is there any order by which the passport authority has stated so?
Application. So it actually the order I have not filed. The entire application of backside eviction. It's their handwriting. Passport authority's handwriting.
But the problem is that suppose
it is visa.
Suppose let us assume that because the problem is there is no such order by this is Judge Family Court Bhubaneswar.
Sir,
the Judge Family Court Bhubaneswar has not discussed anything regarding passport application.
So actually that was there. It was applied that I have to apply for visa and all those things. So in the meantime, the passport has expired. Period of passport has expired. The matter is pending before your lordship.
And have you examined Passport Act, Mr. Agarwal?
Why?
Is there any restriction on that? Passport Act again?
There is no such restriction.
So let's say
I'll show your lordship the
So Mr. Mishra, I think this requires your intervention. So instead of they approaching the court, they should talk to you what exactly they want. I think there is some confusion because passport is kind of an identity document. Passport has nothing to do with whether somebody is getting a visa or Indian passport is Indian passport.
So passport is without the passport, no visa
can be processed. So passport is a document like you can say what you call a gross example or a not so fine example like a voter ID card or a Aadhaar card. It has to be issued by the authority. So, but here I think you are seeking passport, but the father is not cooperating.
Yes,
that is your case. Now, what this in green say the letter the minor applicant parent should furnish or obtain permission from the court to apply for a passport, but he doesn't refer to any order. So I cannot presume that if there is a court order, maybe possibly there is or maybe
court order is deferring the matter relating to visa, and so they have said that
if you read it starts with passport actually. 711 can you look at take page 47.
Yes.
But passport authority is not a party there.
No,
it is more kind of a REIT application.
It may not be required to be made with party. If they refuse for any other reason, then I can seek for direction.
So this refusal is 14/5 of 2025.
The visa is valid of Chile.
Mr. Agarwal? Mr. Agarwal?
Yes. Sir, actually previously
डेट विषय मत कहतु जो 14/5 लिखा है 14/5/25
आगे नहीं
सो 711
सेटा 25 नो
26 your lordship 26
ताले तो then it is still worse
26
confusion is still worse case is not worse
my lord what has happened is my lord
earlier they applied before the passport authority, Your Lordship. There they refused to renew the passport on the
On
ground.
what basis? So
On the
that I
ground-
want to know.
Your
If
Lordship.
the passport authority, perhaps the REIT application will lie.
Mali.
Issue I mean,
No, we are not challenging that, sir.
no, sir. Suppose there is a absolute refusal.
Right.
Then I think the best course is to file a REIT application regarding passport, not entangle this CP.
They have not refused.
Okay.
Sir,
But why they will seek a clearance from the court
Right.
without referring to any court order?
The court order, actually, they are not so concerned with the case. Now the dispute is pending. We have disclosed them. We have to disclose. We have said that the matter is pending in the court relating to guardianship and ward act, all those things. The husband is not cooperating. So they say unless you get a clearance from the court, we cannot process it. Here, this simple question is, previously the boy had been to Canada, where the mother was working and coming here India. Intermittently, she is spending more time here and more time there, or online work is going on. This time she wanted to take the child to Canada for the purpose of summer vacation. Again, he has to come back and study here.
That is custody, sir.
Sir,
That
not
is custody. Suppose they are
we don't
fighting it out. They are fighting it out. The mother wants, the father doesn't want, or maybe the father wants.
Sir,
mother doesn't
custody
want.
is another thing, but custody actually there is no dispute so far as present dispute is concerned.
No,
We
if-
say that
if the child is taken by the mother, then see the child. His child
Is
is
there-
boy or a girl.
the child with the mother,
Child is a boy.
right with the mother.
Okay.
Child is with the mother. She is prosecuting a study in Bhubaneswar right now. Your Lordship's order is there to that effect. This is for an interim management for summer vacation.
No, because I don't understand when there is no such order by any court regarding passport. And anyhow, even if the mother has the custody or say father has the custody,
Right.
the child's passport is independent of that. That is how I was telling you that they should talk to you.
That is exactly.
If they trust or if are they present? Parties are present here.
Yes.
Both parties are present.
So do they understand what is the litigation about regarding passport? Not this CP.
Right. So previously the child with the visa was there. Previously passport was
Are they
there.
comfortable talking in open court?
Yes, yes.
Ask them to come forward.
ये भी एक-
Passport expired at that point.
अच्छा.
Passport application, who had filed the both of you understand Odia English, whichever way you are comfortable, you can speak. Passport application ki apply karthile? ଆପଣ ପିଲା ପାଇଁ apply କଲେ?
ଆଜ୍ଞା
So,
ଆଜ୍ଞା my lord.
so ଆପଣଙ୍କର ତ application ରେ, is there any reference to any court order? Custody, yes, custody is there, custody issue is there, but there is a concept of contact and vegetation rights, vegetation and contact right. So the child is in your custody.
ଆଜ୍ଞା ମୋ ପୋଜିସନରେ ଅଛି
ଆପଣଙ୍କର vegetation and contact right ଅଛି?
ନାଇଁ ମତେ allow ବି କରୁନାହାନ୍ତି
Allow କରୁନାହାନ୍ତି?
କଥା ହେବାକୁ
ମାନେ,
allow କରୁନାହାନ୍ତି ଏବେ
have you filed any application for vegetation and contact?
Yes, before
File
the
କରିଛ?
land court.
ସେଥିରେ କଣ ହେଲା?
ନାଇଁ ହେଇନି decision ହେଇନି.
ମାନେ pending ଅଛି, okay.
Pending, it is
Okay.
pending.
ତାମାନେ now the issue is custody, the child is in the custody of mother is having the custody. Then is there any custody application pending?
Yes.
You are seeking custody only contact or vegetation or pura custody ଚାହୁଁଛନ୍ତି?
No. She had filed the custody for child.
So you had filed the custody?
Yes.
Earlier filed.
Earlier you had filed custody application. Then the custody of the child was with the father.
With the father.
So what happened to that custody application?
sir sir
Pending. It is pending.
That is still pending.
Still pending.
In her application, your contact and vegetation is
Pending.
pending. But rather, those facts are interesting because usually the custody is filed by the person who is not having custody. But here, though he doesn't have custody,
Initially, the boy was with the father. Both were staying together.
during pendency,
Yes.
it has happened.
She has come back. And then after filing the application, the husband also agreed. She has come back to mother. Mother had taken to Canada. She has come back. And thereafter prosecuting at Puri. Correct?
No.
The Puri school ରେ ପଢୁଥିଲେ।
ପୁରୀରେ ପଢୁଥିଲେ ନା ପୁରୀରେ ପଢୁଥିଲେ
We wanted to
Well,
take
the fact remains, she remained with the father from 2019 to 2025. 25 what happened?
ସି ନା ହି ଆଜ୍ଞା
Sorry, he.
ତ ସେଇଟା ଗୋଟେ ଜାଗାରେ ବୋଧେ ଜଜମେଣ୍ଟରେ ଭୁଲ ଅଛି
He remained with the father.
ଯଦି ସି ମାନେ ଆପଣ ମିନ୍ କରୁଛନ୍ତି ମଦରକୁ ଦେଲେ still well and
No.
mother was with the father no problem
It was a misspelled one. It is he.
so even you are scared to state that
He was in the custody of the father.
I am not at all discussing that ଆପଣ ବୁଝିପାରୁନାହାନ୍ତି what I am trying to understand is something different. I am only trying to understand why this passport situation has arisen.
The fact remains
Because here Mr. Barisal, custody is filed by mother who is having the custody. Now, kindly allow the sentence to be completed so that you can understand how I am thinking. I am just sharing. And interestingly, the visitation and contract right is filed by the father who is having custody as per the custody petition. Now, there is a third issue regarding passport. The court ends up directing regarding visa, but the passport officer writes from the clearance from the court. But my understanding is that, say, birth certificate, let us assume birth certificate or those kind of certificate like voter ID card or Aadhaar card, now children are issued. Those are nothing to do with the custody, maybe with the parentage. The parent's name has to be mentioned, any of us. I mean, both the mother, you might be having your card, passport, you might be having your Indian passport. Because all of us are required to, sir has traveled to foreign so many times, he has Indian passport. So that way you did it. So then where is the controversy for issuance of passport?
Controversy is actually she wants to take the child away from the jurisdiction from this.
Passport hele, then you have to show a case law or a provision where during pendency of a custody application, passport can be a issue. ଆପଣ ଶୁଣନ୍ତୁ ଆପଣଙ୍କ ପ୍ରୋବ୍ଲେମ କଣ ଅଛି କହିଲେ like all matrimonial causes, all matrimonial cases, things are being imagined beyond imagination. ଆପଣଙ୍କର issuance of a passport to a child, how it will amount to taking away the child? Because passport is an identity.
I draw my lord's kind attention to page number.
Passport act ଛଡା ଅନ୍ୟ କିଛି page ପଢନ୍ତୁ ନାହିଁ ଆପଣଙ୍କ ପ୍ରୋବ୍ଲେମ ହଉଛି କଣ କହିଲେ whatever is being thrown to you by your client, you are just
Lord, para 40, I mean page 40, running page 42, para 10.
question କଣ para 40 ସେଟା କେମିତି ଆସିବ answer?
She wants to take the child.
ଆପଣଙ୍କୁ ମୁଁ ପଚାରିଲି
get him
multiply 3 into 2. ଆପଣ କହିବେ ଏଟା alphabet ପଢନ୍ତୁ ABCD, ଆପଣ ସେଭଳି answer ଦଉଛନ୍ତି।
ସେଠି admission କରିବା ପାଇଁ କାନାଡାରେ admission କରିବା ପାଇଁ that was the purpose.
Sir ଶୁଣନ୍ତୁ ସେଇ ଯୋଉ purpose ଟା how the court or how can you argue that?
It is their own admission.
अरे passport କଥା ପଢିजे ଆପଣ
passport କଥା ମୁଁ କହୁନି। My lord, I am not talking.
Mr. Barisal, you have to raise your you are not an ordinary person. The question is very pointed and specific. The question is that issuance of passport, how it comes a issue before the custody battle or the court adjudicating the custody. ଯଦି ହେଇଛି ତାହେଲେ କହିବେ ନା ନାଇଁ ଆପଣ ଗପିବେ ଯାହା ଆପଣଙ୍କ କ୍ଲାଏଣ୍ଟ କହିଛନ୍ତି ତାଙ୍କ ଇଣ୍ଟେନସନ ଦେଖନ୍ତୁ ପାରା ପେଜ 40 ଦେଖନ୍ତୁ sir these things are not helping us in adjudicating. Looking at your stature and experience, you are expected to know all these things and you definitely know, but you cannot be emotive. ଆପଣଙ୍କର ଗୋଟେ you have to give an answer, intelligible answer based on law.
Rightly
ଯଦି ଆପଣଙ୍କର ଶୁଣନ୍ତୁ, there is a possibility the passport can be an issue in the custody, but to my mind, my understanding, by reading of Passport Act or any act or even this Minority Guardianship Act, it cannot be an issue because even passport has to indicate the father and mother's name identity. Correct. So you want to apprehending that see the child will be taken away, suppose you are saying
yes
ଆପଣ ତାହେଲେ ମନିକା ଗାନ୍ଧୀ ପଢିଛନ୍ତି?
Maneka Gandhi, Article 21, no doubt about it. But Kansakra case,
no doubt about
passport. Yes, he has the authority actually to get the passport done in his fellow. No doubt about it.
Oh, no doubt about it.
I mean,
that's for Seti pe Maneka Gandhi pe Seti no.
Right. Life includes this right to travel.
Kuntu seta the child right, independent right habani. So apanakara passport cannot be prevented. Maneka Gandhi said in that context, at least as I expected you that with your age and experience and stature, you know this. So how can the passport be an issue before the custody court? Because the reason being, Suppose Maneka Gandhi was not issued passport by a order of a administrative authority, restraint to travel. Even Maneka Gandhi also, the court said that post decisional hearing, it can be restrained. But here there is no restraint. Now, in that context, I was asking you if pendency of a custody is regarding anything to do with passport. I think
Nothing.
it cannot be.
Oh, let me, I seek some time.
Are 6 some time kona je agya mu buji parnu. Apana, why do you want the passport should be a issue before the custody court? That's the question to you.
Custody issue will be ineffective.
Apana karo. Apana jo time nochoni kon pa time nochoni.
The point that my lord actually raised, that whether passport should be issuance of passport can be an issue in child custody case, only on that part.
Oh, so the point kon achi chitre. There's nothing.
My point is,
it is absurdity. Have you sought you cannot seek an injunction against a passport.
No, I'm not seeking.
So then why you are complicating the things? ଆପଣଙ୍କର ମନେକା ଗାନ୍ଧୀର ଆର ସେଟଟା ଭାବିଲେନି ବୋଧେ ପାସପୋର୍ଟ ଜଣଙ୍କର ଥିଲେ ଆପଣ ପାସପୋର୍ଟ ଥାଇକି ଜଣକୁ ଟ୍ରାଭେଲ କରିବାକୁ ଆପଣ କଣ ଆପ୍ଲିକେସନ ଦେବେ the child cannot travel or the mother cannot travel, father cannot, she can say that father cannot travel, who knows?
My friend will not disagree with me that the passport was there, it's only for extension of time that it has lapsed.
I don't understand how the passport authority has passed an order like this. Then I'm searching for the court order. You see, Mr. Barisan, suppose I am to look at this also. So then that is the reason I was asking you. Was there any order for restraining about issuance of passport?
No.
Then?
No restraint.
Then?
But only passport authority said that consent of the...
Mr. Mahanti, you are Mr. Mahanti. Yes, Mr. Mahanti, what is your apprehension regarding issuance of passport?
Sir, actually, ମୁଁ ଜାଣି ନଥିଲି ତାର ପାସପୋର୍ଟ ସେ ତିଆରି କରିଥିଲା ବୋଲି 2021 ରେ କୋଭିଡ ସମୟରେ ତାଙ୍କ ଘରକୁ ନବା
fair enough ଆପଣଙ୍କର ପାସପୋର୍ଟ ତିଆରି ହେଇଗଲେ ଗୋଟେ ଲୋକର ଠିକ ଅଛି let us assume ଆପଣଙ୍କ ପିଲା କଥା ଛାଡି ଦିଅନ୍ତୁ ଆପଣଙ୍କ ନିଜ କଥା କହିଲେ ଆପଣଙ୍କର ପାସପୋର୍ଟ ତିଆରି ହେଇଗଲେ କଣ ଅସୁବିଧା ହବ
ପାସପୋର୍ଟ ତିଆରି ହେଇଥିଲା ଭିସା ପାଇଁ ବି ଯେତେବେଳେ ସେ ଆପ୍ଲାଏ କରିଥିଲା
ସେଟା କାହିଁ ଯୋଡୁଛନ୍ତି ସେଟା କାହିଁ ଯୋଡୁଛନ୍ତି ଯେ ଆପଣଙ୍କର ପାସପୋର୍ଟ ତିଆରି ହେଇଗଲେ ଆପଣଙ୍କର ଭିସା ହେଇଯିବ ବୋଲି କାହିଁ ସେଟା ଯୋଡୁଛନ୍ତି both are unrelated. In fact, surprisingly, the court has court empty situation create kale. Court arambha kale para 1 re passport, last re lekhile visa. Because this was the confusion before the court most likely.
Lord, she is a permanent resident of Canada. That is the problem. Nothing else.
The problem kon hela mu buji panu. Apanakara permanent resident of Canada kara pilankara passport hobani.
She will be removed from this jurisdiction. That is only my apprehension. Nothing else.
Are seti pai passport so kon sampark achi apana injunction karichanti ki?
The injunction done.
What? Talk some sense, some legal, make some legal submissions.
Your lordship.
Apanakara jo emotive, she is a permanent resident of Canada. She will be removed. Tara apanakara case sangare kon sampark seta ketso mu pacharibe apanku.
The custody will be infructuous.
Custody kon infructuous.
Once he will be
custody apanakara custody hela pore apanakara passport hela pore apana passport re se visa paibe ki ne seta issue na passport issue kariba ta issue rela.
That is
how can you deny a rather at least you are facilitating the child being identified as Indian citizen.
Let them give an undertaking that yes, passport can be done, but provided she should not be shifted.
Why? Under which provision?
No, not provision.
So don't speak nonsense, Mr. Barisan. Lawyers should not speak peace in a court. Undertaking kahaku debe? Kahaku debe?
Honorable court.
What provision?
No, provision. This is a discretion or
No,
honorable.
never. Illegal orders are not to be passed by court. Being persuaded by lawyers, what you are saying. That is absolutely illegal order. How can I direct somebody to give an undertaking?
The custody again.
You must understand. You can make this prayer before a court which is taking up the custody matter. Have you filed upon the nijo kamada kori nahanti? Have you filed an injunction?
No.
Have you made a prayer? Then?
The liberty may be given.
What liberty I will give you? Have I curtailed your liberty?
No.
What is this, sir? That is one of the more reasons I wanted to speak in the chamber. Because these things are not we are being watched. What is being deliberated in a court? That you are saying that the passport, if they will give an undertaking before this court, High Court is no way connected. In how many cases High Court is taking undertaking pending matters in trial court?
Not this question was raised in GUAP. It should have been raised in writ application.
Either you say you are answering or don't say anything. But you can't go on speaking In how many cases the High Court takes undertaking for pending matters in trial court?
It's on court discretion. I'm not talking about
In which case, yes, how many cases discretion has been exercised?
civil matters.
Which case? Any single case?
Civil matters.
Sir, this is absurdity. This court doesn't have jurisdiction. This court doesn't have power also to trial a matter, and it will take undertaking. Have you read Peri Consagra versus Priti Madan Consagra?
That judgment.
Which paragraph you are relying?
My lordship actually on the last occasion actually referred to that judgment.
I am not asking you to give a speech on Smriti Consagra versus Smriti Madan Consagra versus Peri Consagra. Which paragraph says that passport cannot be issued at the
No, I don't
Supreme?
remember the paragraph.
So find out.
My lordship actually passed last occasion. The order passed was that in response to the said submission, it was specifically asked by the court whether the application of her passport of a single mother in future, as is being contended, can be made or not by the petitioner number 1 after she is allowed the custody of the minor child. In response, the learned counsel of the petitioner.
Discussion last order. What is being discussed? Do you understand what is being discussed? Be fair with you and to me, to the court also. Not at all being discussed. What is being discussed that the passport authority has passed an order in a paper that get clearance from the court. Now the natural question is that which court has inserted or interdicted or passed any interim order? Then all of you are struggling. As Mr. Agarwal struggled, now you are struggling, and you are carrying the imagination of your client. Then you are saying that issuance of passport amounts to she will take away the child or he will take away the child. Then whether on this apprehension passport cannot be issued, then you say some provision, then you are struggling. Some case law, you are citing Peri Consagra versus Smriti Madan Consagra. Have you read Peri Consagra?
But I don't remember the exact paragraph.
So if you have read, then you would have understood what I was talking to you. Did you make an application? What was the security accepted by the Supreme Court, directed by the
1 crore.
1 crore. Did they ever satisfy that? There the child was a major or a minor?
He became major subsequent.
Remember, sir, always when you are citing, don't expect that the court will forget and court would not have read. There even the Peri Consagra is a model accused in that country. The boy said that he wants to have that because he's a multi-billionaire. The court accepted the version of the child. He wants to go and stay there. So even in that case also, the grant was conditional. Even custody and transfer was granted conditional. So those things are part of the custody matter. Basically, we are not in this matter. In fact, while at the cost of mine, court time, I have asked specifically which matter is pending where. Both of you have apprised. Then I invited the parties to say which matter is pending where. Your answer, both of you agree, Mr. Agarwal and you, both of you agree that yes, custody was with the father, the mother filed custody application. Now the custody has shifted to mother, the father has filed in her application registration and contact rate, but no, there is no separate custody application pending. You must understand, Mr. Banisal, you are appearing in High Court. Without these applications, you are saying that you are apprehending the mother will take away the child to Canada. You may apprehend. What is your how the court will assure? Assuade your or satisfy your apprehension. Maybe assuade is the appropriate.
Because
word. You see, have you sought for any injunction from High Court? Have you moved any application before the trial court having jurisdiction?
Only we have sought for the.
So you must understand. You must review your approach also, and please don't make every single issue regarding the child as if it is a fight between you and the mother and father, both of you. You should never do that. Never do that. You are grown up enough, you are responsible enough. You are lucky to have a counsel like Mr. Barisale and senior Mr. S.P. Misra. Everyone will not have those counsel. So don't make it an issue. You see, in fact, at the end of the day, I am yet to understand then where to start and where to end because there is no reference to any passport matter. Suppose you want prevention of, you want injunction from the child being transferred, taken away to another country. Is this the way to approach by preventing issuance of passport or birth certificate?
Actually, ଯେତେବେଳେ ପାସପୋର୍ଟ ତିଆରି ହେଇଥିଲା ମୋର କନସେଣ୍ଟ ନିଆ ହେଇନଥିଲା। ଏବେ ଯେତେବେଳେ ମୋତେ କନସେଣ୍ଟ ପଚରା ହେଲା ମୁଁ ସେତେବେଳେ RTI ପକେଇଲା ବେଳକୁ ଜାଣିଲି ଯେ ସେ ତା ଦେହରେ ଫଲ୍ସ।
ସେଟା ଆପଣଙ୍କର ମନେ ନାହିଁ, ମୋର ସେଟା ମନେ ଅଛି।
ଆଜ୍ଞା।
I have a difficulty, ଗୋଟେ କଥା ବାରମ୍ବାର କହିଲେ some I don't like. ଆପଣ ସେଟା କହିଥିଲେ, even last ତା ପୂର୍ବ ଥର ବି ପଢିଥିଲା ମୋର ମନେ ଅଛି। So ଶୁଣନ୍ତୁ, ଆପଣଙ୍କର ଯଦି ଆପଣଙ୍କର if you understand, because are you a student of law? I'm a student of law. I have to tell you that what I mean to say. Suppose in the first instance the consent of the father is not taken, and next time the passport is renewed and father's consent is to be sought for, will it lead to a situation where passport cannot be issued? Then being a student of law, I have to tell you that there has to be a specific provision in the act that Mr. Barisal or Mr. Agarwal, they will help you. Don't imagine things like that. So that will lead to a situation where you are running after things which are non-existent. Suppose let us assume that the passport is issued. Issuance of passport will lead to a conclusion where the child will be taken into another country. Can it be? Unless so that is your apprehension.
Temporary ପାଇଁ ଯେତେବେଳେ କରିଥିଲି ସେଠି ଗଲା ପରେ ସେଠି ଜବରଦସ୍ତ କରୁଥିଲା ଏଟା ପର୍ମାନେଣ୍ଟ କରି ସେଠି ରଖେ।
I guess that is internal. That has nothing to do with law or the proceeding before the High Court or the trial court or the passport authority. ଆପଣ daily ଘରେ କଣ ଝଗଡ଼ା କଲେ, your imagination, your perception about each other, your imagination and perception about the shortcomings of each other, because both of you are judgmental about each other, that will not impact the operation of law. If you want to say that something is there regarding operation of law, issuance of passport, then make out and bring some case on record at least. I cannot understand what the trial court has written, because it was so argued before trial court, the trial court got confused. Because visa authority is is beyond. Visa authority, is it subjected to the territorial jurisdiction or legal jurisdiction of the Indian court? Bhante, have you any idea? Because unless you are a student of law, you cannot understand. The visa authority is a sovereign authority. The sovereignty of the state is continued in the embassy itself. No court can interfere in operation of visa process. Have you marked that how many visas are being reduced by the American authority? Have you ever seen that anyone approaching High Court or Supreme Court or trial court? Because visa is something else.
But she was threatening me. Not threatening करतला जे मुझे।
Sir, I told you that, sir. Your threats, perceptions, apprehensions, quarrels, or good relationship has to have a legal consequence. ଆପଣ ଗୋଟେ ट्रायल कोर्ट से एते got so much confused, ଭିସା ବିଷୟରେ ପଳେଇ ଗଲେ। ଭିସାରେ ଆପଣଙ୍କର ट्रायल कोर्ट କଣ କରିବ? ସୁପ୍ରିମ କୋର୍ଟ କରିପାରିବେ ଭିସା ବିଷୟରେ କିଛି? କାନାଡା ଭିସା ହଉ କି ଆମେରିକାନ ଭିସା ହଉ? H1B ଭିସା ତାଙ୍କର ଯୋଉ ଦିନ ଇଚ୍ଛା ହେଲା ସେଦିନ ସେ ରିଡ୍ୟୁସ କରିଦେଲେ। There is a process of visa.
Visa is there.
They are the authority. That has traveled throughout the world.
Can interfere in those affairs.
No, in fact, that cannot be a subject matter here also. First of all, आपण passport visa confuse ହେଇଗଲେ. Second, आपण कहला जे passport ହେଇगଲେ visa ହେଇଯିବ भाबिले. Passport ହେଇଗଲେ आगे visa हुएनी. Passport पाई visa मोर भी confusion आरंभ ହେଲା.
So by the time the
passport हेले visa हबनी, must be clear on that. Second କଥା ହେଲା पासपोर्ट नथिले वीसा हेई परिबो सेटा आउट जिंस तापर आपण जणे आपणकर जो मानकर पासपोर्ट रे अछि से माने जदि फॉरेन को चली जिबे these orders are passed day in day out by this court, more so by the sessions court and civil court.
Actually,
yes, Mr. Barisal, what are the orders passed regarding passport?
no, they actually wrongly written visa
ଛାଡନ୍ତୁ ସେଟା
in the
ଆଜ୍ଞା
order.
ଛାଡନ୍ତୁ ଆପଣଙ୍କୁ ଯାହା ପଚାରୁଛି ସେଇଟା ଆପଣ ଯେତେବେଳେ ଆପଣ ପଢିବା କଥା ପଢିଲେନି ବର୍ତ୍ତମାନ ଆପଣଙ୍କୁ ପଚାରୁଛି ଆଉ ଗୋଟେ ଜିନିଷ passport regarding every day in day out what kind of orders are passed by the court
Obviously, it is independent.
independent call to surrender the passport there are so many orders ସେଥିପାଇଁ ଆପଣଙ୍କୁ ମନେକା ଗାନ୍ଧୀ ପଚାରୁଥିଲି ଆପଣ ମନେକା ଗାନ୍ଧୀ ପଢିଛନ୍ତି କହିଲେ ତାପରେ କହିଲେ ଯେ Maneka Gandhi arose of a application before Supreme Court that when she was directed to surrender her passport, she could not to travel into foreign country. Se prakara proceeding hele, suppose there is a proceeding pending before the trial court for any kind of that kind of a order, then I mean you can sit, madam.
Read should have been filed actually for this purpose.
And I don't know. Apanakara read katha nahi. Apanakara read file kare to alga katha. Apanakara this is not an issue also.
And passport authority should have been made a party here. Passport authority should have been made a party, and the read should have been filed.
Ajay, but why the trial court has interfered here? Mu bhi buji paune. Apanakara prayer
One IA was filed by the petition. One IA was filed by the petition. It is out of the IA they have come up in GUP. And in the IA, they have mentioned that we have already taken admission, we have already discussed in that school, in a French school in Canada, so we'll take the child. That was the pleading. Page 42, para 10.
Yes, Mr. Mishra, I think if the passport authority, because since there is no order as such, this court, there is no order in GUP. So this court may not have jurisdiction in GUP. GUP no, should have to call CP.
Yes, GUP.
CP. If there is any order in CP, that is challenged in GUP. So there is no such order where there is any restraining.
That order, if you still looks at the bundle of confusion, in fact.
Yes.
It's 50.
Yes, the prayer was to direct for renewal of the passport without requiring the consent of the father.
ଆପଣ ଆପଣ କନସେଣ୍ଟ ଦେବେ ନାହିଁ ପାସପୋର୍ଟ ପାଇଁ ଚାହୁଁଛନ୍ତି
ମୁଁ ପାସପୋର୍ଟ ତ ମୁଁ ଜାଣିନଥିଲି ତିଆରି ହେଇଛି ବୋଲି ଭିଜା ଯେତେବେଳେ ସେ ଆପ୍ଲାଏ କରିଥିଲା ଟେମ୍ପୋରାରୀ ଭିଜା ତାକୁ ଯାହା ହେଲ୍ପ କରିବା କଥା ଇଭେନ୍ ତାଙ୍କ ଟିକେଟ ଫିକେଟ ସବୁ କରିଥିଲି ଗଲା ପରେ ସେଠି ଫୁଲ ଏଭ୍ରିଥିଙ୍ଗ ଗଟ୍ ଚେଞ୍ଜ ଆଉ କହିଲେ ଯେ ସେ ଆସିବନି ଇଣ୍ଡିଆ ଆସିବନି ସେଠି ସେ ପାସପୋର୍ଟକୁ ଯୋଉ ଭିଜାକୁ ପରମାନେଣ୍ଟ ଭିଜା କରିକି ସେ ରଖିବ କହିଲେ ମୁଁ ଯେହେତୁ ପରମାନେଣ୍ଟ ରେସିଡେନ୍ସି ଅଫ କାନାଡା ମୋ ଛୁଆକୁ ଚାହିଁଲେ ମୁଁ ପରମାନେଣ୍ଟ ରେସିଡେନ୍ସି କରିବି ଆଉ ସେଇଠି ରଖିଦେବି ଆଣିବି ନାହିଁ ମୁଁ ଯେତେବେଳେ ମୁଁ ଆଉ ରିନ୍ୟୁ କଲିନି ସେଠୁ ବାଧ୍ୟ ହେଇକି ଆଣିକି ପୁଣି ଛାଡି ଦେଇକି ଗଲା ପୁଣି ସ୍କୁଲରେ ସେ ପଢିଲା ତାପରେ ଅକ୍ଟୋବର ମାସରେ ହଠାତ୍ ଆସିକି ସ୍କୁଲରୁ ପିଲାକୁ ଲୁଚେଇକି ନେଇକି ଯାଇଛନ୍ତି ଭାରି ତାପରେ ସ୍କୁଲରୁ ତାକୁ
ଆପଣ ଯେତେବେଳେ ଘଟିଲା ଆପଣଙ୍କ ସାଙ୍ଗେ ଯାହା ଘଟିଲା ଆପଣ ଯେତେବେଳେ ଓକିଲ ପାଖକୁ ଗଲେ
ଆଜ୍ଞା
ଆପଣଙ୍କୁ ଓକିଲ ଯଦି ଆଡଭାଇସ କରିବେନି କଣ କରିବା କଥା ସେଇଟା ତ କିଛି କରିହବନି ଆଉ ଏଠି ତ ଆଜ୍ଞା ପଞ୍ଚାୟତ ନୁହଁ ଯେ ମୁଁ ଏଠି ବସିଛି ଯିଏ ଯାହା କହିଲା ଆପଣଙ୍କ କଥା ଶୁଣିବି ତାଙ୍କ କଥା ଶୁଣିବି ଆଇ ହାଭ୍ ଟୁ ଗୋ ବାଇ ଦ ରେକର୍ଡସ ମଷ୍ଟ ଅଣ୍ଡରଷ୍ଟାଣ୍ଡ ଦ୍ୟାଟ୍ ତେଣୁ ଆପଣଙ୍କର ମେ ବି ଆପଣ କିଛିଟା ଜିନିଷ କରିବାର ଥିଲା ଯଦି ଆପଣ ଚାହୁଁଛନ୍ତି ୟୁ ସୁଡ୍ ହାଭ୍ ସର୍ଟ ତେଣୁ ଆପଣ କଷ୍ଟଡି ତ ଫାଇଲ କରିନାହାନ୍ତି କହୁଛନ୍ତି ନିଜେ You have not filed any custody. ଆପଣ ପାଖରେ କଷ୍ଟଡି ନାହିଁ କିନ୍ତୁ ଆପଣ କହୁଛନ୍ତି ସିଏ ଫାଇଲ କରିଛନ୍ତି
ଯୋଉ ଦିନ ଗଲା ସେଇଦିନ ସେ କଷ୍ଟଡି ଫାଇଲ କରିଛି ଯୋଉ ଦିନ ନେଇ
ଆପଣ କଷ୍ଟଡି ଫାଇଲ କରିବା କଥା ତାହେଲେ ଶୁଣନ୍ତୁ ଆପଣଙ୍କ ଯଦି ଲିଗାଲ ରେମେଡି ବାହାର କରିବେନି
counter claims
when you are fighting it out within your amongst you parents are fighting or you are fighting for the custody and all those things you have to find out a legal solution to that because perhaps both of you will not agree for a negotiated solution ଆପଣ ଆଗ୍ରି କରିବେ ଯେ ଗୋଟେ you can ଆପଣଙ୍କର ଯୋଉ parentage plan ଦେଖିବେ in any custody application when there is a parentage plan you will see that there is a proposal by the parties written together that the child will stay here, stay there, study here, everything is written and you submit to the court and you agree before the court. You can take your seat.
So we can do it also.
Yes.
For this summer vacation, the boy will go. He will again come back. He will study wherever he is studying. And both of will cooperate each other
But Mr. Mishra, the problem is that they will listen provided they trust both of each other. After they trust each other, they will listen to your said advice.
An understanding will be there that can form part of the record also.
They are there, Mr. Barisal, you can work out. Because I think they have lost their way in the litigation. But I think this is the second case we are handling in a division bench. We are handling with justice in division again same Canada. But there the father was took him to Canada. We directed that the grandfather will accompany. They are from Raigada or Jaipur. But so they are. This is not the case. I think this is from Puri. And here the mother stays in Canada.
Both sides. You can stay with the father for some time.
Lack of trust lack of trust you have become apprehensive. You are apprehensive about issuance of a passport. You will have become apprehensive about issuance of any identity card. And the strange logic you are putting is that for passport visa hejibo.
The visa actually was valid during, at the time of filing of this GOA. It was valid. It actually expired the month of February.
যদি প্রশ্ন পচারিবি ভিসা কো যায় ভ্যালিড থিলা আপন উত্তর কোন তালে দেবে দুইটা প্রশ্নর একা উত্তর হই পারিবে I never asked you that visa was valid till when. Once you have started trusting each other, and the unfortunate part is that both of you, both mother and father, you are expressing your mistrust through your child. That should not happen. ଆପଣଙ୍କର ଯାହା ବି ହଉ ପଛେ, but I think both of you are responsible enough to take care of the child, and the child should be the uniting factor. Now she is about 15 years. Now he is about 15 years.
11 years, sir.
11 years. 11 years. I know.
ଆଉ ସିଏ 2021 ମସିହାରେ 19 ମସିହାରେ ଟ୍ରାଏ କଲା ଫରେନ୍ ଯିବ ଭାରି ସିଆଡେ ରହିବ ଆମ ଛୁଆ ମତେ ଦି ଜଣଙ୍କୁ ଛାଡିକି ସିଆଡେ ପଳେଇଛି ଆମେ ଦି ଜଣ ଯାକ ଏକାଠି
ଆପଣଙ୍କର ଶୁଣନ୍ତୁ ଆପଣ ଯଦି ମତେ ପର୍ସନାଲି ପଚାରିବେ ମାନେ I completely support her decision to leave you and her child. It is her independent decision. She is a human being.
Sir, this is
because the way Mr. Mohanty, it is like this. I told you it's a coincidence. The father took the mother passed away, unfortunately. The child stayed with the grandparents. That the father went to Canada. See, he wanted to take the child to Canada. There is a custody battle. Obviously, the father, being the natural guardian, has to have the custody. The district court decided. Then the parents are not grandparents are not handing over the child. So you cannot take exception. That's why she decides to go to Canada and stay there with her child.
सर मु तांको पई अपेक्षा करथिली मो पाखरे रेकॉर्ड अछि मु 1.5 वर्ष अपेक्षा करली मते सब थर कहले हां देखिबा बिकॉज़ मो ईयर मोर स्पाउस और मो छुआर भी हे परथांता लास्ट को जते बेले से मना करि चलले 1.5 वर्ष मते मो मैनेजर अल्टीमेटम देले यू हैव टू रिपोर्ट और एल्स बिकॉज आम साइन करू गोटे बॉन्ड जो हमको पठेबे मते चेन्नई पठेले जुआड़ पठेले मु गली इनिशियली आई माइग्रेटेड विथ हिम वेरेवर ही वेंट गोटे जिनस मु कहली जिबा बाहर को ना हाँ देखिबा कही जते बेले फाइनली मैनेजर मते देले मु दी थर मोर ट्रैवल रिक्वेस्ट को कैंसिल करछि इट टेक्स अ होल लॉट ऑफ प्रोसेस टू रेज अ रिक्वेस्ट इट गोज थ्रू अ बंच ऑफ अप्रूवल फ्रॉम HR फ्रॉम लॉट ऑफ थिंग्स इनसाइड कंपनी फाइनली अल्टीमेटम देला परे मु लैंड करली सेठी 50 थर मु आसे ओ को देखा करे भिक मागे जीव हो देखिबा छुआ को छाड़िबो ना ओ तू ताल से
still आपनकर भितरे one thing I can tell you, looking at you, I have more experience of life. You will be as experienced as Mr. Mishra is. But both of you have still lot of chemistry between you, lot of emotions.
Together, sir.
Yes.
You can stay together.
Yes. That is my independent observation that the way you have proceeded, you have both of you should have been more careful with each other. More caring about each other, not careful. You have been careful, but more caring about each other. You talk to each other. It can come next week. You find out. Mr. Mohanty, ଆପଣଙ୍କର ଏଇ ଯୋଉ ପ୍ରୋବ୍ଲେମ ପାଇଁ ହିଁ ଆପଣ ଆଜି ଏଠି ଲ୍ୟାଣ୍ଡ ଅପ୍ କଲେ ଆପଣ ସସ୍ପେକ୍ଟ କରିବା ଆରମ୍ଭ କଲେ ଯେ ପାସପୋର୍ଟ ହେଲେ ହେଇଯିବ ପିଲା ପଳେଇବ ଆଜ୍ଞା ପାସପୋର୍ଟ ଥିଲେ ସବୁ ଥିଲେ have you marked that that is how I was telling that The mother in Smriti Kansagra said in the Supreme Court that I'll sacrifice everything. I have sacrificed everything, as Mr. Mohanty says. I don't know whether you have sacrificed. She says that I have sacrificed my career. I am a full-time, I have devoted my entire life and entire time to the child. How the child can be transported to, that's African country. I think that's Kenya.
Kenya.
Most likely Kenya. They're very, very rich businessmen there. And he said that regarding the character of the person, that he is extremely erratic, he behaves badly, he's addicted to liquor, and he's a murder accused. In that scenario also, the Supreme Court granted the custody to the father against whom all these allegations have been made, because the child wanted to pursue his life there. Even it was argued by on behalf of Smriti Kansagra that the child needs a better quality of life than that's been proposed to be there at Kenya. Still, so I mean, law is that the child's wishes. He's an adult. He wants to study there. He wants to have this. He can study anywhere, any big college of. His father is capable of paying his fees anywhere in big university. So in that case, this apprehension that even if you are having, she is having passport, by stopping the child from having a passport leads to nowhere. The reason being, even if the passport is not issued to him, she can have custody, she can win the custody battle. The converse is equally true. Even if the child is having the passport, you can win the custody battle. Because in Smriti versus Perry won. So that is a future determination by the court which will adjudicate your custody application. And if you can work out a solution where both of you and the child has the fortune of having the love and attention of both mother and father, nothing like it. Again, we are coming back to that point that both of you should not have your exchanges through the child. Upon the sentimental, emotional being a parent about the child, can the mother not be? Has to be. So it is only a matter of perception. In fact, these questions are asked to the children. So children at times they say, please. So that way, please consider that. And there is absolutely no, as far as the legal issues are concerned, Mr. Barisal, there is no such provision that a passport authority can be interdicted by the guardianship court. Maybe the family judge. But there is no such provision.
From a read application, actually,
no.
The passport authority as a party.
Yes, Mr. Misra. So, since there is no such order, I may not, right now I am not passing any order, of course. But there is no such order to be interfered by this court in the GUAP.
That order itself is something different. As exactly I said. When I sought permission from the court cannot say you have to wait. I am not grant it. That itself staring at me. That is the reason why the passport authority have said that we cannot pass. Right?
Copy. Passport authority copy that.
Tuesday, Asu.
I think suppose if the mother wants to challenge that order, if they are anyway, then I think since this order is nothing to deal with that, perhaps the writ petition is the only answer.
For granting permission there's a different part. For interfering with this observation. But the order that has been passed in 7-11, that stares at me. So this order itself, I think they have got a copy of this order.
7-11?
25.
Okay, in here.
Says 747.
Paragraph? 47.
Internal.
Say you internal which is subject matter of challenge. Says you last to go I do not find kind of urgency whether the pleading the petitioner can so adjudicate only during course of trial. Therefore, cannot
What
take
is the
into
prayer?
consideration.
What is the prayer?
The prayer was to
Prayer only
Achha,
to
passport authority for renewal.
yes. Now that is the reason
I
why
think I think if you find the application
right.
and withdraw that IA, read petition file kari that if that would be ए जोटा IA टा किए फाइल कले
IA 86
IA आपण फाइल कले
yes.
I think that IA was not required.
Exactly.
IA टा सेठी जो हला ताजर confusion नहीं गला.
Correct.
And the trial court आरंभ कले माने passport रू सॉरी गला.
So बर्तन ए ऑर्डर टा बोले समय पे हम तो बोले unless you get a
This order can be challenged. This order can be challenged in 227.
Actually, this was not placed before the passport authority. Passport authority challenged because this that's C on form number C that says that
problem मुझे आपण ते order टा देखंतु
annexes
मोर जोटा कुचोती सेटा को annexer C माने को order रे सेटा
passport authority जो passport issue है
अरे GOP रे
ना GOP रे नहीं
so that is the problem mu to same question I am baffled with that I am entangled in that question the CP 666 of 2025 re which order was passed pursuant to which application
say you passport authority annexer C टा देखो सर act रे is 54 थियो
that Mr. Borisal is saying that C रे गोटे जो अछि
आगे
सेटा को से कले but my question was that whether that formed a adjudication required adjudication by the custody court CP re so that he is saying no
like the E says
C page
54 थियो सेटा annexer C
54
D and E
C अछि specimen declaration by the applicant's parent or guardian.
आगे
Yes.
See D and E. What's the book say?
Yeah, I think C will be the appropriate. When one parent has not given consent.
Annexer C रे देखो सर.
Annexer C when one parent has not given consent. Page 54. Same book.
E there is a court order for the custody of the minor child. With the parent who is applying for the passport, consent of the other parent who has parent right is not available. If they refuse to give consent, the other partner is not availing the visiting right. Then D says there is an ongoing court case for divorce or custody of the minor child. The court has not given the order prohibiting issue passport without consent of the child. So this gives a right me to get it. Because of this order 7/11/2025. Court is not, the authority is not exercised.
When did you apply for the passport? But application you are saying it is 26.
26 after the
I asked that in fact. So after 7/11, this green order is of 26 is
26 legal.
September 2025.
September
2025.
2025.
Written
recent patient
it a written totally
9/10/2025. And a rescheduled date. Apply.
But Mr. Mishra, if you read Roman 2, Roman 2 is something which says that you can state that reason and get it. Signature.
Yes.
Consent of Srimati, name of the father, mother, who is the father, mother, parent of the child has not been obtained by me for the following one of the more reasons. So she is not required to get the also. And in fact, she was the child has got a passport also.
Yes.
So there is no application, no need for applying to the court.
No. We are not applying for court.
Court application diye chahiye 86
Because the court case is going on, therefore,
Because this,
Made an application.
because Annexer C says, just read again the Roman 2.
Do you signature consent say Srimati?
Yes.
Then A, B, C, D.
No, sir. I am not reading there. Signature, consent of Sri. Here it will be Sri says whoever. Sri Srimati, name of father, mother, Roila.
Okay.
Who is the father, mother, parent of the child, has not been obtained by me for the following one or more reasons. So has this Annexer C दिया है चुकी?
Again.
Annexer C टा को कितने आए फिर दिया है?
The truth. You are thinking.
कोर्ट रेकॉर्ड रे नहीं सेटा.
ये असली तो काली है.
Is there any prohibitive order for issuance of passport?
No.
Also, then I have understood correctly. This has to be challenged in the writ application. But the thing is that, but ultimately I was not discussing whether passport should be issued or not. I was trying to counsel both the parents that they should not make a issue for every interaction between them. The child is the medium.
So
Rather, they should have a plan. I mean, beautiful plan for the child.
So that I was talking to both of them. Both of them want to stay with each other and cooperate, but I don't know how this has to happen. The kitchen difference of opinion, I accept this.
It doesn't seem like there is a difference.
So no major problem with them.
No major problem. And one thing can be assured to both of you that much bigger problems are faced between the husband and wife. And both of you are lucky enough not to have those problems.
But here
you have your fair share of problems, but not those bigger problems.
Independently, respect to all those things, say that if unless your lordship clarifies this order 7/11/2025 should not.
No, I think I cannot clarify in exercising GUAP.
No. What I need to say, sir,
there has to be a separate application.
No, this order itself should not stand in the way for considering the application for passport.
No, sir, because I have checked and rechecked. There is no such order by court directing not to issue passport. Because
so see, the court has deferred it. Exact what is that last sentence?
No, that was not the ground for denial of the passport. As the ground has not been mentioned.
No ground is required. You had permission from the court.
Because it has said, upon a seat I mentioned करछन ना, ठीक देखिले आउथरे फॉर्म रे. I have read it. C ना D mention करछन.
C has been mentioned.
D mention करछन.
E does A B C D.
अपना टिक कोटा मारछन.
E.
अपना E टिक मारछन. There is a court order for the custody of the minor child with a parent who is applying for the passport.
We have not given any prohibited order.
There is no such court order.
No, sir, no such court order.
आपका D हवा कथा. अपन भूल टाइप टिक मार दीजिए.
But sir, we are not divorced or judicially separated.
No, said of the divorce.
So you have to read it like this.
Okay.
There is an ongoing court case for custody.
Yes.
Divorce mention करिबेन सेटा oblique टा.
No, sir.
Either आपनकर divorce थिले सेटा आगो 26 अछि. Divorce provision न लगा.
No, sir. C टा किंतु लिखा है parents are divorced or judicially separated and custody and married together and also.
नहीं annexer C ना अपन कोड आगे.
Annexer C.
इटा कोड है.
Annexer C here.
Match करूनी को.
No, sir. That's होती.
अपन C देखंतु. Here the D reads, there is an ongoing court case for custody of the minor child and the court has not given any order prohibiting the issue of passport without the consent of father, mother. Divorce तो definitely no, because there is no case pending.
Oh, sir. Say D टा होची एठी E. Certificate रे जो annexer C टा ଦେଇଛନ୍ତି ସେମାନେ format ଏଠିକାର D is ତାଙ୍କର E. Same thing.
ତାଙ୍କ ଇରେ କଣ ଲେଖା ହେଇଛି ପଢିଲା?
ତାଙ୍କ ଏଇରେ ଲେଖା ହେଇଛି parents are divorce, sorry, there is an ongoing court case for divorce oblique judicial separation, including the issue of custody of minor child. Court has not given an order prohibiting the issue of passport without the consent of the father. Exactly same ଜିନିଷ।
ତ ongoing word ନାହିଁ ଜମା।
ହଁ ଖାଲି
ଆପଣ ପ୍ୟାରାଗ୍ରାଫଟା ଦେଖନ୍ତୁ। But should annexure C ନୁହଁ as prescribed in this act?
ସେ ନିଜେ ତିଆରି କରୁଛନ୍ତି।
ସେ ନିଜେ ତିଆରି କରୁଛନ୍ତି। amended ହେଇଯାଇଥିବ।
ଆଉ ଗୋଟେ ଅଧିକା ଲେଖିକି ABCDE କରିଛନ୍ତି।
ଇରେ କଣ ଲେଖା ହେଇଛି?
ତାଙ୍କର F ଟା ଲେଖା ହେଇଛି there is an ongoing court case for divorce judicial separation including the issue of custody child। ଆଉ ଗୋଟେ
ସେଟା ହବନି sir because ସେଟା ତ ଅଲଗା ଜିନିଷ section 26 ଆପଣଙ୍କର ଇଟା
ଇଟା ମ୍ୟାଚ୍ କରୁଛି ଆପଣଙ୍କର ବହିର D ଏଇଟାର E।
ବହିର D କରେକ୍ଟ।
ଆଜ୍ଞା
ଆପଣ ଏଠି ଡିଭୋର୍ସ ଟା କାଟିବାର ଥିଲା।
ଷ୍ଟ୍ରୋକ୍ ଦିଆହେଇଛି
ତାହେଲେ ବା ଜୁଡିସିଆଲ ସେପାରେସନ ଟା
ଡିଟା କଟା ହେଇଛି ନା
କଟା ହେଇଛି।
ନାଇଁ ବିଲକୁଲ କଟା ହେଇନି ସାର୍ ଏଟା ଭୁଲ ହେଇଯାଇଛି।
ଏଇଟା ଷ୍ଟ୍ରୋକ୍ ଦିଆହେଇକି ହେଇଛି ତ ଓବ୍ଲିକ୍।
ସାର୍ ଏଟା ଭୁଲ ହେଇଯାଇଛି ସାର୍ ଏଥିରେ କଷ୍ଟଡି ୱାର୍ଡ ହିଁ ନାହିଁ।
ଅଛି ନା
ଆଉ ଗୋଟେ କୋଉଠି ନା କଷ୍ଟଡି ୱାର୍ଡ ନାହିଁ।
ଇରେ ନାହିଁ କଷ୍ଟଡି
ନା ମୁଁ ସେଇଥିପାଇଁ ଆକ୍ଚୁଆଲି ଆଇ ୱାଜ୍ ଷ୍ଟ୍ରଗଲିଂ।
ସାର୍ ଆପଣ ସେ ଯୋଉ ଫର୍ମାଟ ଟା ତାଙ୍କର ଦେଇଛନ୍ତି
ସେଥିରେ କଷ୍ଟଡି ୱାର୍ଡ ଟା ହିଁ ନାହିଁ।
ଅଛି ନା ସାର୍?
ନାହିଁ।
ଇ ଯୋଉଠି ଟିକ୍ ମରା ହେଇଛି
ସେଟା ତ ସାର୍ 26 which I was telling. It reads there is an ongoing court case for divorce, judicial separation. There is no such case.
नहीं सर नहीं सर
ଆପଣ just act ଟା ସାର୍ ଦେଖନ୍ତୁ act ଟା ଦେଖନ୍ତୁ act ରେ ଯୋଉ appendix ଟା ମାନେ printed ଯୋଉଟା ଅଛି act
ଆପଣ ସାର୍ ଯୋଉ ଫର୍ମ ଟା ଫାଇଲ ହେଇଛି
ଏଇଟା
ସାର୍ ଇଟା ଦେଖନ୍ତୁ ସାର୍।
ହଁ ନାଇଁ ଆପଣ ତ ଇ ଟିକ୍ କରିଛନ୍ତି ନା ମୁଁ ସେଇଟା ହିଁ ପଚାରୁଥିଲି ଆପଣ ଗୋଟେ ଭୁଲ ହେଇଯାଇଛି ସେଇଟା ଭୁଲ ହେଇଯାଇଛି ସାର୍।
ସେ ଗୋଟେ ବ୍ରାକେଟ ଅଛି ଇନକ୍ଲୁଡିଂ ଅନ୍ ଦ ଇସ୍ୟୁ ଅଫ କଷ୍ଟଡି ଅଫ ମାଇନର
that is section 26
ଆଜ୍ଞା
divorce case ରେ section 26 ହବନି but ଏଠି ଆପଣ ଦେଖନ୍ତୁ interestingly what it reads in fact she is aware of that she says that there is no case pending एठी सर कहिला there is a court there is a ongoing court case for custody of the minor child it is very clear sir।
अब से ଗୋଟେ एफ रे नुआ जो ऐड कर से एफ रे देखो सर
ସେଥିରେ ବି ନାହିଁ।
H
next page ରେ ଅଛି
one of the parents is willing to deny willfully denying to give his or her consent supporting documents and so
এই ଯୋଉ ଫର୍ମ ଟା ଆପଣ ଏଟା ଆନେକ୍ସର सीटा କୋଉଠୁ ଆଣିଲେ?
ସେଇ ତାଙ୍କର ଡିପାର୍ଟମେଣ୍ଟ
website
ନାଇଁ ଏଇଟା ତ ୱେବସାଇଟ ଭୁଲ ହବା କଥା ନୁହଁ ଆପଣ ତ ଏଟା ଦେଖନ୍ତୁ
सर ଏମାନେ ଚେଞ୍ଜ କରୁଛନ୍ତି ଆମେଣ୍ଡ କରୁଛନ୍ତି from time to time
sir this is ଏଟା 2025 ର sir
25
तो ଏଟା ତ ତାପରେ ଏଟା ଆମେଣ୍ଡ ହବାର କିଛି କାରଣ ହିଁ ନାହିଁ ଏଟା ଗୋଟେ ଟାଇପୋଗ୍ରାଫିକାଲ ମିଷ୍ଟେକ୍। ତାପରେ ସାର୍ ଆଉ ଗୋଟେ ଦେଖନ୍ତୁ ସାର୍ ଆପଣ ମିଷ୍ଟେକ୍ ଇଜ ଆପରେଣ୍ଟ ସାର୍ ଆପଣ ଏଫ୍ ଟା ବି ଦେଖନ୍ତୁ ଆପଣଙ୍କର ଇ ଆଉ ଏଫ୍ ଦୁଇଟି ଯାକ ରିପିଟ୍ ହେଇଯାଇଛି। That is the apparent mistake sir। ଇ ଯାହା ଏଫ୍ ସେଇଆ
नहीं सर एफ टारे there is a prohibitory order
ମୁଁ ସାର୍
prohibiting the issue of passport.
ସେଇଟା ଠିକ ଅଛି
But now it's not.
ସେଇଟା there is no but ଆପଣଙ୍କର ଟାଇପ ହେଲା ବେଳେ ଆପଣଙ୍କର ସେ ୱାର୍ଡ ଟା କଷ୍ଟଡିଟା ହିଁ ନାହିଁ ଆଗରେ this can be changed. This is statutory.
Sir, procedurally, these forms are
So
subject.
what has happened problem is for the perhaps. So of course seven से form रे apply कले but से form रे जोटा से custody वाट टा ही नहीं.
It must be amended.
नहीं. My hunch is that it's a mistake
But it is available.
because this cannot be amended
No, this is a
because
actually-
no person can be authorized to change these contents of this prescribed forms annexes.
That I'll check out whether
Well,
it's
check
amended
करो तो।
legally. We'll check out. Because statute cannot be amended.
No.
Statute can change without amendment.
But wherever the statute contains the like foreign gain mining leads,
Right.
for annexer C in passport and passport rule is very also otherwise strictly interpreted.
Yes. But Tuesday.
ଆପଣଙ୍କର what I was pointing out just read A to I nowhere then custody word is there. Whereas in D and E both paragraphs in book in the Bear Act the custody word is there. But it should read that the ongoing court case for custody of the minor child.
Including the issue of custody.
Well, Tuesday I should.
Yes.
You're thinking that.
The GUAP 16 election, the GUAP is listed along with. The WPC 758 of 2026, 764 of 2026. Writ petition टा काहे की 758 टा कौन पे?
Again.
That is for say school method.
So this is school report here.
Sir, that will become very infructuous ହେଇଗଲାଣି କାହିଁକି this is already admitted.
764
7 से ଦିଟା को combine ଗୋଟାକରେ ଥିଲା
ତାହେଲେ ଠିକ ଅଛି ଗୋଟାକରେ ଲେଖ. GUAP 16 of 2025. The Lord Senior Advocate Mr. Mishra along with Mr. Agarwal for the petitioner and Mr. C. Orissa were had at length. The parties being present in court were also asked to participate by lending their views in the ongoing discussion in the matter. After interacting with both the petitioner mother and as well as the opposite party father, apparently both the parents love their child. They are really concerned regarding the welfare of the child. However, as the events have unfolded, the mother has shifted to Canada. Was there?
So
She is having a Canadian visa. You are having a Canadian visa.
Yeah, permanent resident.
She has a permanent resident visa from Canada.
Actually, permanent citizenship.
Okay. She has a permanent resident permission. What is that called?
Sir, it actually permanent work permit.
She has a permanent work permit to work at Canada. The CP has been filed before the London Judge Family Court Bhubaneswar, that is CP number, CP पर दे number पकड़ दे, CP number 26 of 2025 has been filed before the SWAT.
Yeah, वो main petition detail कुछ कुछ भी
Has been filed before the Learned Judge Family Court.
main petition.
Under Section 7 of the Guardians and Wards Act, 1890, read with the Hindu Minority and Guardianship Act, 1956, and Family Court Act, praying for an appropriate decree appointing petitioner number 1, that is mother of the child, as the guardian. The further prayer in the said CP is for injuncting the respondent father from removal of custody of the petitioner number 2 child. It is submitted that can I record that she is now having the child, or I am not going to that because I am not discussing that aspect also.
See, the child is with the mother.
Yes,
Yes, with the mother.
it can be recorded.
From October 2025.
From October.
2020.
Now it seems from October 2025, the child is in the custody of the mother. Though
Date may
though
be
any
mentioned.
other application
9th
has not been filed, but the father has filed vegetation and contact the father has filed application seeking vegetation and contact rights with the child. Number Janchandi,
No, pending that's
which is pending before the Learned Judge Family Court, along with the CP 666, as stated today before this court. The prayer made in the present application is challenged to the order passed by the Learned Judge Family Court dated 7/11/2025 in IA number 86 of 2025. The IA was filed by the petitioner wife seeking a direction to the passport authority for renewal of the passport of the petitioner number 2. During the extensive hearing today, both the Learned Counsel for the Learned Senior Counsel for the petitioner and the Learned Counsel for the opposite party, as well as the parties in person, were heard whether such an issue can be raised before the Learned Judge during the Learned Family Court during pendency of the CP seeking custody. From the tenor and contents of the order, it seems though the Learned Family Court delved into the issue of direction to the issuance of direction to the passport authority, but at the concluding paragraph, the following has been observed. Para. the reason for seeking a direction to the passport authority when prior to the application was made on 7/11 upon application केबे कले?
Application was pending before.
During pendency of the application is not very clear.
No, sir, before that.
The learned counsel for the opposite party as well as the opposite party in person are very apprehensive regarding issuance of the passport to the child on the ground that issuance of passport would lead to a situation of grant of visa to the child. So that, sorry, no, not so that, visa to the child, which will lead to which will further lead to a situation. The child being taken out of India. That is to Canada by the mother along with her. In considered view of this court, this such kind of correlation and extension of the sequence is not contemplated in law. On being asked, the learned counsel for the opposite party submits that regarding the custody of the child and he being transported to Canada, taken to Canada is not an issue before any of the courts, as such an issue is yet to be raised. Okay. It is further submitted that the petitioner, the opposite party herein, apart from apprehending that the child will be taken to Canada by issuance of Indian passport, is not is a perception, is an individual perception of the father, though there is no other material to support such apprehension. It is stated by the learned counsel for the petitioner as well as the learned counsel for the opposite party as well as the opposite party appearing in person that earlier Indian passport was issued without informing the father. To the said proposition, the answer would be that if issuance of passport to a child is possible through either of the parents, that is maybe father and mother, the said such passport having been issued without knowledge of one of the father or the other public mother, as the case may be, cannot be made an issue. So, the parties are having been spoken to at length. It is hoped that they will agree for a situation, they will agree for the welfare of the child with arrangement for shared custody, parentage, stay, etc. Regarding which they need to talk to each other as well as to the learned counsel, including the senior counsel representing the petitioner. The matter shall be listed for orders on 20/5 मंगलवार ना बुधवार on 20/5/2026. Mark that 3 p.m. ଆପଣଙ୍କ ବୁଧବାର ହବନି ବୋଧେ ବୁଧବାର ମିଷ୍ଟର ସାମନ୍ତରାୟ is arranging party. If the clients are invited, then no problem. They are not inviting clients. তাহলে 19 তারিখ করতে 19 তারিখ Yes, sir. Anything to be
No.
okay. The other writ application should be disposed of.
Yes, sir.
Okay.
Sir, I would have khali IR of 4 of 2026.
Yes.
First verify.
Forgery mu entertain koruni.
Sir, actually,
Because if I have not considered anything or passed any order relying on the statement, then I will not go into that. The reason being, then what is the difference between a henchman and a lawyer? Why people go to henchmen? Musclemen. They give them money and they do whatever they like. Then what is the difference? So this individual acrimony cannot be converted to the
No.
The individual acrimony between the parties should not be utilized to motivate a lawyer to file applications. That's my understanding.
yes,
Yes. ଆପଣଙ୍କୁ କାହାକୁ ବାଡିଆ ପାଇଁ କାହିଁ କୁହାଉନି କାହିଁ କୁହାଉଛି ଆପଣ
Affidavit ଟା ପାଇଁ କହୁଥିଲେ ଆଉ nothing else. ଖାଲି affidavit ଟା ପାଇଁ ଆଉ nothing.
ଆଜ୍ଞା ଯଦି I think largest assignment ହବ ଖାଲି ଆପଣଙ୍କର ଯୋଉ ଭୁଲ affidavit ର separate bench କରିବାକୁ ପଡିବ.
She was not in
Day in, day out. I mean, these kind of mistakes or deliberate mistakes are being done. Our entire bail jurisprudence is developed on that only. Yes. Best. What the process of proof. The matter is mentioned at the beginning of the day's proceeding. The appearance Ochanti, P. Das for the petitioner. Nay, Ochanti, Tibrewal. Petitioner by Ketina? P. Das. Saurabh Tibrewal, A. Khadelwal, P. Khadelwal,
I'm there, Your Lordship.
Mr. Saurabh Tibrewal for the petitioner, Mr. Pratik Das for the opposite party. এটা করছে 20 তারিখ কইলা আছে আপনি
Your Lordship, mediation next day is 22nd of June. It has been fixed, Your Lordship. So any day at thereafter, Your Lordship.
সে না সে কোন 20 তারিখ রখিয়া ପାଇଁ আচ্ছা জুলাই কইলা আচ্ছা ঠিক আছে yes I'm sorry I marked it that to be June. So Pratik Das for the opposite party they submitted that the mediation date is fixed to
22/6/2026, Your Lordship.
22/6/2026. According to the matter shall be listed in the week commencing 20/7/2026. The interim report, mediation report shall be placed before shall be placed on record. Yes.
Lordship, there is an interim order in their case.
Interim order ଆପଣଙ୍କ second matter
We see 22 of 25, Your Lordship.
second matter interim order করতে হবে interim order dated so and so passed in TRPC 22 of 2025 shall continue in the next status hearing. আর যদি সেপারেট অর্ডার করিব তাহলে সেপারেট লিখে দেবে
Serial number.
yes 19
Published.
Serial number.
অর্ডারটা করেকশন করব ঠিক আছে জজ দেখি দিও 19 রে কোন কইলে সে বুঝিলে
Sir, my IATA जो फाइल है nomenclature change କରିବା ପାଇଁ
हां
ତେଣୁ ଆମେ ଚ୍ୟାଲେଞ୍ଜ କରିଛୁ
ତ nomenclature change କରିବା ପାଇଁ ମୁଁ जो कहूची ଆପଣଙ୍କୁ कहूची ଯେ ଆପଣ nomenclature change करा जाऊ ଆପଣ adjournment କାଇଁ କରୁଛନ୍ତି nomenclature change ଚାହୁଛନ୍ତି ନା ଚାହୁନାହାନ୍ତି
yes
ঠিক আছে তাহলে I have understood correctly 22 ରେ লেখନ୍ତୁ the order number 3 has been inadvertently typed out as order number 2. Accordingly, the order dated as shall be corrected. The order number being order number shall be order number 3. 19 ଲେଖନ୍ତୁ ଆପଣ ନା ଅଛି ଲିପି ସରି ଆପଣ ନାଁଟା ଭୁଲିଗଲେ
Lipsa Mudra Swai.
ଲିପ୍ସା
Lipsa Mudra Swai.
Lipsa Mudra Swai for on behalf of Lingaraj Sadangi for the petitioner. Item 19. IA 15 of 2025. The IA has been filed for conversion of for the change of nomenclature from RPFAM to CRLMP. Stamp report dated 16/12/2024 indicates that at entry 9 that the matter to be registered as CRLMP. Accordingly, the prayer made in the IA is allowed and the IA is disposed of. Registry shall do the needful for change of nomenclature. The petitioner shall take steps for change of the nomenclature. Yes. Item 23.
23, there is a delay in filing this GUAP. There is 70 days delay.
What is the challenge to order regarding custody granted to the mother?
Yes, no, we have filed the custody application. Father has filed the custody application before the family court, which was dismissed.
Okay. Item
And,
23. Okay, document upon it. GOP item 23, the Mr. Biplab PB Bahali for the petitioner. Opposite party blank. IA 8 of 2026 along with GUAP 5 of 2026. The petitioner before this court is the father of the child. The challenge is to the judgment dated 27/9/2025 passed by the learned judge family court Paripada, district Mayurbhanj, in G.M.C number 41 of 2024. The said application was filed under Section 25 of the Guardians and Wards Act from 1890, seeking custody of the child. Their son from the mother, wife of the petitioner, from the mother of the child, wife of the petitioner. By the impugned judgment dated 26/4/2023, the application seeking custody was dismissed. Stop. The IA has been filed for condonation of reported delay of 14 days in filing the appeal. Had learned counsel for the petitioner who is present in VC. Stop. Para issue notice along with this order to the opposite party. Issue notice to the opposite party along with this order. Requisites for issuance of notice by speed post with registration and proof of delivery shall be filed within 5 working days.
5 working.
Within 5 working days. Returnable date be fixed to (29/6/2024). The matter shall be listed in the week commencing 6/7/2024. ଆପଣ କେବେ କହୁଛନ୍ତି ଡେଟ୍ 6/7 102 ହେଇଗଲାଣି ଠିକ ଅଛି shall be listed in the week commencing 13/7/2024. Yes. So after notice matter, since paucity of time intervenes, it will not be possible. Order ଡକା ହବାର ଅଛି
No. Important to mention that item 26 related to Monday or Tuesday. 26. Because he is suffering from cancer, for that only I am praying for.
Even the orders matters are hard, fresh admission are hard. So it will be difficult to take up. ଯଦି କହୁଛନ୍ତି ଆସିବ ଠିକ ଅଛି ନେକ୍ସଟ ୱିକ୍ ଆସିବ 26ଟାକୁ ନେକ୍ସଟ ୱିକ୍ ଆଣନ୍ତୁ ନେକ୍ସଟ ୱିକରେ ଆପଣଙ୍କର ଅଛି 122 already 122 matters are posted that you must realize 26ଟା ଆଣନ୍ତୁ ବାକି matter ଗୁଡାକ if you want specific date after vacation or he will be posting it.
Item number 24, there is an interim order. The petitioner has expired. We had filed an IA for substitution after serving copies on the parties. Today, since the matter is not being taken up, can the interim order be continued?
So 24, what is the nature of the interim order? Because I am not passing
The nature of the interim order.
I am not touching any order.
So, order of status quo.
Whatever order was there, that remains intact. I have not passed any order.
Then let it be, Lordship. I'll not press for that.
Who interim order ta thila कहले?
There's an interim order of status quo in this case number
7/7/25 रे.
again. There's an interim order.
So there is an Sam S. Agarwala. The petition, upon a petitioner ko pai.
I'm for the petitioner.
24 opposite party. So PP Behra, Prabhu Prasanna Behra for the OP number 1. One TO to 5. OP6 black. The matter is listed for.
I'm happy for OP number 6.
OP6.
I'm there for the OP5.
Itire. Achha, sorry. Well, 1 to 4 ele Mr. Prabhu Prasanna Behra. 5 Mr. Samir Misra, Senior Counsel, along with Pragya Mahanti. 6 re apan ko na achi.
No, Lordship. On behalf of Mr. J. Pal.
You are Mr.
R. Mahapatra, Lordship. Mr.
R. Mahapatra for the
OP number 6.
Mr. J. Pal along with Mr. R. Mahapatra for OP6. The matter could not reach as paucity of time intervened. Is mentioned by the learned counsel for the petitioner regarding extension of the interim order. Interim order dated
Lordship, interim order dated 22/3/2013. Order number 4.
2013.
This case number 4929 of 2013.
The problem is that the interim order has been extended intermittently. Somewhere it is extended, somewhere not extended. Anyway, interim order dated, regarding extension of the interim order dated 12/3/2021. The interim orders dated ete shall continue to the next date of hearing. ତା ପୂର୍ବରୁ ତ ଆପଣଙ୍କର ଆପଣ 13 କହୁଛନ୍ତି ନା
22/3/2013 order number 4.
22/3/13 okay 22/3/13 yes. Second item रे sub item रे कौन हबो?
Sub item
listed for admission in the week commencing
Sub item.
27/7 for admission in the week commencing 27/7. Sub item रे की appear करछन जोटे लिखि के दे दियो.
I am for the petitioner. Sub
I
item.
am appearing for petitioner in sub item 2.
2 रे प्रकाश कुमार मिश्र for the petitioner opposite party same. अपन सर कहाँ पे? प्रकाश कुमार मिश्रा along with Mr. You are Mr. R.K. Sahoo.
RK sir.
Prakash Kumar Mishra, R.K. Sahoo for the petitioner. Opposite party same रहे. Third item रे किए?
Third item, I'm for the petitioner.
Yes. So, popular author senior counsel along with Ms. Shraddha Das. Opposite party same. Fourth, Mr. Lalitendra Mishra. Mr. Abid Lalitendra Mishra along with Mr. A. Sahoo.
Yes, ma'am.
A. Sahoo for the petitioner. Opposite party same.
Because my power was.
Along with the Mr. Mr. Lalitendra Mishra for the petitioner with A. Sahoo lecture. Item 25 to 27. ये डेट चाहूँ
Item 27.
27, yes. After vacation date कर दियो.
Yes. वो कहाँ थोड़ी Item 37. Oblige मैंने.
Your Lordship, may I please, Your Lordship? Your Lordship, item number 29, Your Lordship, there are two numbers of matters, Your Lordship.
Yes.
I pray Your Lordship to direct the matter to be listed, both the matter to be listed on the first week of July because there were mediation going on, Your Lordship.
Item
29 टा ताले 13 साथे ना 6 साथे 6 साथे से already he has posted 102 matters.
13/7, Your Lordship.
13 साथे कर दियो तो.
Interim order in both the petitions shall continue, Your Lordship.
I'm not touching any interim order.
Your Lordship, Your Lordship.
Because you see now after the court hours I'm not passing orders.
Your Lordship.
Yes.
Your Lordship. Grateful, Your Lordship. Grateful.
Yes. 29. Okay. 30, Madam Mahanti, ଆପଣଙ୍କର 30 କଣ ହେବ?
The vacation.
Date may be fixed, my lord.
Right, 30 date କରନ୍ତୁ ଆଜ୍ଞା.
27.
27 ହେବି.
Interim management lordship. That
Interim ମାନେ କଣ adjournment ନା stay?
Adjournment petition. 19/12/2025.
The 30 लिखिए the matter is listed for hearing under the heading for admission, comma could not reach due as paucity of time intervened is mentioned by the learned counsel for the parties. Stop. Appearance लिखिए Miss J. Mahanti for the petitioner, Mr. A. Mahanti for the opposite party.
Ashutosh Mahanta, ma'am.
Mr. A. Mahanta. You are Miss P.S. Mahanti. Yes, Miss P.S. Mahanti for the petitioner. Okay. 30 date केबे देले 30 टा
वो कमिंग 27.
27. That shall be listed for admission in the week commencing 27. The learned counsel for the petitioner seeks for extension of the interim order. So accordingly, it is directed. को interim को दिन थिला कहले
19/12/2025 lordship order number.
Dated 19/12/2025. So
Para 7.
Dated 12 टा मिळू नाही काही. TRPCL later. So I 14. I have opened another link actually. Accordingly, the 1cc case number 5856 of 2023 pending before the learned JMFC into bracket COP dash Roman 2 bracket close Bhubaneswar shall be adjourned to a date shall be adjourned beyond kete date apno korchanti 27 shall be adjourned beyond 31/7/2026 as will be convenient to the learned court upon a prayer being made for the state purpose.
30. Publish. May I please, item number 32.
32, yes. What do you want, sir?
After.
Date चाहूँ
Again.
32 date कर दियो.
We come to 27.
27
27.
27 for admission.
35 lordship.
Lordship, item number
Yes, 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 that's
Lordship, item number 33.
33, yes.
Can it be possible to be taken before vacation?
No, I mean, the pattern of this thing and the time consumed in hearing fresh admission and orders. I can 33 asu next week देखियो how listed how
आसु आगे आसु सप्ताह रे आसु
देखा जाओ. Yes. Let us-
35 it's my matter.
Yes.
छुट्टी पर गोटे डेट
35 गोटे डेट करो तो आगे
29 ले मो प्रेयर करछि नहीं 47
अरे से ऑब्वियस पॉसिबल डेट दउछोती काना 29 से 96 मैटर कर साले
के 26 रे काई कहूची ना एतरे मोर गोडाउन डार सब सरी जीव सेत
29 थरे आसीबो कहउछन तो 29 वीक रे हां वी कमेंसिंग 29 छ आसु.
Lordship 36 item
36 yes madam.
kindly list a short date.
Shortest तो दिया
It was last year 5
there is nothing short than shortest or shorter than shortest. That you must understand. And this style of posting matters every week is only unique to Odisha High Court. In other High Court, it is 3 months, 4 months. So that you get some other matters listed. And upon the same matter ko repeat hochi, say, in fact, list kariya is not a problem. Podi bata important. Upon kete 36 kochandi.
again
36 ke date karantu. Short date karantu, madam kochandi. 13/7.
37.
ଆପଣଙ୍କ 13/7 ରେ 28 ଟା ଅଛି ସେ ଯୋଉ 6/7 ରେ 102 29/6 ରେ 96 ଟା ଅଛି. Yes
37.
yes
Already adjourned to 27.
Hmm.
Only interim payment.
ए 37 ରେ मिलिटरी बॉर्डर टच करनी सर जदी एडजर्नमेंट डेट जेंती कले
No, already adjourned.
कहले मैडम कहले एबे
Yes.
नहीं स्टे ना कोन अछि
So,
Stay-
adjourned.
stay थिने दैट absolutely no apprehension of any modification of the order. It has to continue.
Yes.
TRPC 98.
Suppose that order tax adjournment.
Gotcha. Mr. Ashok Kumar Patnaik for the petitioner. Mr. Patnaik.
No, Jenna. Yes.
Mr. S. Jena for the petitioner. The matter mention किए करथिले ना?
First time what page no opposite party actor को
अच्छा Ms. A. Misra, Arunima Misra. Ms. A. Misra for the opposite party. The matter being in the list for hearing under the heading for admission was mentioned at the beginning of the day's proceeding by the Learned Counsel for the opposite party. Taking adjournment accordingly was posted to 20/7/2026. The Learned Counsel for the petitioner also mentions the matter at the end of the day's proceeding, seeking extension of the interim order. It is 17/4/2026. Accordingly, it is directed. The CP number 105 of 2026, pending before the Learned Judge Family Court Puri shall be adjourned to a date beyond. ଆପଣ କେତେ ତାରିଖ ଦଉଛନ୍ତି 20/7 ନା 20 beyond 27/7/2026 as would be convenient to the Learned Court in season of the matter upon a prayer being made for the said purpose. So, the matter shall be listed in the week listed for admission in the week commencing 20/7/2026. Okay. Yes. Completed list of this. Thank you. Thanks for your time.